Welcome to the joint hearing of the House and Senate Judiciary Committees, and we're looking today to learn a little bit more about public safety and access to justice, specifically focusing on the backlog and in the courts and the processing of cases and the speed of processing cases, the speed of having consequences and such. So in any event, we're going to start with Commissioner Morrison. So over to you.
Good morning.
I'm sorry, actually before we start, does it make sense to go around the room and just introduce ourselves, because we're early and the commissioner may not know all this. So I'm Martin Malone, representative from South Burlington, chair of the House Judiciary Committee.
Good morning, Senator Bob Norris, Franklin County, Vice Chair of the Senate Judiciary Committee, and I also represent the town of Elburg and Grandel County.
Karen Dolan, representative from Essex Junction on House Judiciary.
I'm Ian Goodnow. I'm representative from Brattleboro, and I am also in House Judiciary.
Alicia Millay, representative from Pittsford, Judiciary.
Zach Harvey, representative from Castleton, House Judiciary.
Tom Oliver, House Judiciary. Sheldon Swanton.
Tanya Bihovsky, Chittenden Central District.
Good morning, Commissioner. Tom Burda. I live in West Rutland, but I represent West Rutland, Clarendon, Wallingford, and Rutland Town, and Vice Chair of House Judiciary.
Good morning. I'm Nader Hashim, Senator from Windham County, Chair of Senate Judiciary.
All right, so thank you, and I apologize for having interrupted your introductions by making our introductions.
No worries. I always appreciate that. I'm really good with faces, not always so great with names, but my name is Jennifer Morrison. I am the Commissioner of the Department of Public Safety. For those of you who I have not worked with before, I came to Vermont in 1990 and became a young police officer in the city of Burlington. Never intended to stay in policing my whole career, and ended up serving over 28 years in Vermont communities, specifically Burlington and Colchester, serving in roles, positions, and ranks from patrol officer, detective, through all the ranks. And I became the chief of police in both Colchester and in Burlington. And this is now my 5th year working for the state. It's very hard to believe it's been that long. It's gone by fast, but I've served in 3 different positions at the Department of Public Safety in the past 4.5 years. And in addition to being a career policing professional, I am a wife, a mom, and a very proud grandmother. I'm deeply invested in seeing Vermont thrive and remain a place where my family can continue to grow and create great memories. So that's sort of the background of how I come to you today. I know your time is precious, and I don't intend to take up a lot of time, but I do hope to share a few data points with you. I think data is important, but it doesn't always tell the whole story. It's one piece of any story when we talk about crime or public safety. I'm also going to talk to you a little bit about what we've been hearing direct from Vermont communities, from citizens, from public safety professionals, from local leaders. And I'm going to commit to you that my team is here to help and be part of common sense, fair solutions that help Vermont communities thrive. So I want to start at my last point and work back to the data part. Nothing that we propose, nothing that is going to come out of the mouth of a member of my policy team, nothing that we support is tough on crime or a throwback to antiquated law and order thinking. I just need to put that out there right away. We aren't interested in old ideas that don't work. And everything that we believe in includes compassion for people and deep concern for the health and vitality of our communities. My team tries to be responsive to reality on the ground here in Vermont, not anywhere else, and to bring these issues about public safety that we hear throughout the year to the legislature's attention for awareness and for action. So what are we hearing from Vermont communities? You're going to learn, if you haven't worked with me before, I'm super direct and little unfiltered. So I'll let you know exactly what we're hearing from Vermont communities. People are tired of repeat offenders harming their communities. They're tired of not being able to enjoy public places, parks, spaces for fear of crime, disorder, and intimidation. We're hearing that the pendulum has swung too far away from protecting the common good and considering the public's safety and well-being in favor of allowing individuals to do whatever they want with no apparent consequences. We're hearing that communities are grappling with violent crime and lower level quality of life crimes and everything in between. In fact, in the past year, there have been more special meetings specific to public safety than I can recall in decades. We follow these meetings. We send folks from not just the Vermont State Police, but also from our policy team to these meetings. And some themes that have come up over and over include unaccountable and defiant defendants repeatedly committing crimes despite being on pretrial release. Unmet social service needs coupled with a lack of accountability for certain behaviors that are creating fear in our downtowns. Businesses being hurt by shoplifting, public urination and defecation, and more. People in these meetings are literally pleading for someone to intervene when defendants with mental health or substance use disorder repeatedly commit criminal acts. So my team is here to represent these concerns and to be part of finding solutions that work here in Vermont. The fears and frustrations that we're hearing across the state are supported by Vermont data. In 2024, we had our third straight year with over 20 homicide victims. Specifically, there were 22 homicide victims in 2024. There were 26 victims in 23. And there were 24 victims in 2022. And you can compare that to 11 victims in 2014 and 16 victims in 2015. In 2018, we had 661 aggravated assault cases.
Commissioner,
Yes.
there's a question, Senator Mahowski.
Thank
Yes,
you. Thank you, Chair Lalonde, and thank you, Commissioner. One of the questions I asked when some similar data was given in Senate Judiciary, but haven't yet gotten an answer to, is what percentage of those homicides are domestic violence homicides? I know generally it's somewhere around 50 or over 50%, but I'm curious what that looks like.
I can get you that data. We actually have it. And surprisingly, in the last 3 years, or the first 3 years, that what you just stated is not the case. The number of domestic violence homicide cases has actually dropped, and the number of stranger on stranger, specifically drug-related homicides, has escalated. So we do have that number. I don't have it at my fingertips, but I can get it for you.
Great, thank you.
In fact, we can get you a breakdown of the nature of the homicides.
That would be fantastic. Thank you.
So
Yep.
the domestic violence review reports, one that just came out a couple of days ago, has some of that information. And every year, the past several years, they have that information as well. So that's one of the other sources that you could look at for which homicides and suicides involve domestic violence.
Okay, and if there's any other questions, I'm certainly happy to provide any follow-up that the team feels necessary. So in 2018, there were 661 aggravated assault cases. In 2022, that number had jumped to 969. And in 2023, it remained quite high at 936. So between 2018 and 2022, 2023, we're talking about a more than 40% increase in aggravated assault. Property crime is up as well. Thefts from motor vehicles, as well as thefts of motor vehicles, have more than doubled since 2018. Shoplifting has doubled from 1,672 cases in 2018 to 3,388 cases in 2023. And this hurts our businesses. This causes stores to leave our downtowns, and it contributes to the atrophy of our once vibrant public places and attractive downtowns. I could go on, but you get the picture. And my colleague Tucker Jones has presented more fulsome data, and it, I believe, is already on the website for Senate Judiciary, but he will be presenting it again today, this afternoon. Later today, some of you will hear from the Governor's General Counsel and Tucker Jones, who is a member of my policy team, about the omnibus bill on public safety. I ask that you listen carefully to all of the components and consider their interrelatedness and their importance to the bigger picture of moving the needle a bit more this session towards restoring confidence that we, all of us, the state, will consider the public's health and safety as we handle individuals who, for whatever reason, cannot comport themselves and need swift, certain interventions to do so. The public has pleaded for someone to do something. We are that someone, and it is incumbent on us to take action on their behalf. I know you have a lot of other witnesses, so I'm happy to take questions, but I offer that as a framing wave tops of how our team is approaching our work this session. And you'll hear a lot more detail this afternoon and in subsequent visits with your committees. Thank you.
Questions from the committee or committees?
Commissioner, thank you very much for your testimony again. Your time is not only valued, but greatly appreciated, as well as your service to the state. One of the questions I have is, and having moved back to the state recently from New York City, I can't help but feel heartbroken to see the place that I've called home for so many years, really falling apart at the seams and becoming a place that, I think many Vermonters don't even recognize. A question for you. Do you feel, what I'm hearing is that we have reached such a dire point in the trajectory of the state of Vermont. Do you feel that we have reached the level to declare a state of emergency for the public safety of Vermonters?
I don't think that we can make a global statement like that we are at a state of emergency. I think what is an emergency in one community is not an emergency in another, and that the landscape is a little bit different from community to community. I also think that when we talk about declaring a state of emergency, we have to talk about, have we exhausted all resources at the local level that are available in a community? And that doesn't just mean, have we exhausted all the law enforcement resources? Have we exhausted all the public policy resources that could come to bear on a problem? Have we exhausted prosecutorial options? Have we exhausted judicial options and everything in the toolbox that impacts the conditions on the ground in a local community? So, when I think about what it would really mean to declare a state of emergency, it means that we've done all those things and we have exhausted all local resources. And I don't believe that's the case.
Thank you. Senator Mahovsky.
Thank you. And thank you, Commissioner Morrison. I agree wholeheartedly that we really need to look broad and holistically at how we address the needs of our communities. But I also think it's important that we look at Vermont in the context of the United States and recognize that in 2024, Vermont is still the safest state in the country, and Burlington is the fourth safest city in the country. So I do think that we have to look at the trends nationwide and, yes, respond to the concerns of our constituents, but also recognize that we are still a very safe state, which doesn't mean we don't need to act holistically. So I appreciate and want to just make sure we find that balance.
Yes, ma'am. As a police chief, I've dealt with perception all the time, right? Perception is people's reality, and that is what we, in addition, we don't just respond to data, but that does help us deploy resources in certain ways. But we absolutely have to deal with people's perception of safety or lack thereof in a neighborhood or in an entire community. I think that I am a pretty good barometer of what communities used to look like, because I've been around a long time and I spent a lot of time policing in some communities, and it doesn't look or feel the same in downtown Burlington than it did 15 years ago or 10 years ago. And there are many communities that I go to and visit that I have the same reaction to. Now, that doesn't mean all communities are like that, and it doesn't mean that we can't turn the corner. I believe we can. I truly believe we're in this moment that if we continue to do nothing and allow I'm okay, you're okay, everyone have a free for all, do whatever they want in public spaces, then we're going to continue to go down that path and maybe wind up in a place of needing a state of emergency or other resources. But I think we're in this moment where we can determine that the public good has to be at the forefront of these discussions and decisions at every step of the system. The harm to communities, the harm to our downtowns has to be considered when we are confronted with an individual who needs supports and services. And when people cannot lean into supports and services that are offered, they must be compelled, because we can no longer allow our communities to fray. The fabric of our communities used to be really tight. It's hanging by a thread, friends. And we are in that moment where people are looking to us to help stitch it back together and get back to a place where people enjoy their public spaces and their downtowns and want to spend money there. And in turn, that makes Vermont more vibrant and grows the economy and creates more jobs. I mean, it's all interrelated with all of the governor's priorities. So this is really, really important. And I think we have a great opportunity this session to make a couple more advances that will take us in the right direction.
Great, I appreciate that, and I certainly agree that doing nothing is not an option, and the status quo of our communities and meeting people's needs is not acceptable.
Senator Brew.
Thank you. I just wanted to respond again to the phrase "do nothing" or "we can't continue to do nothing." Both the committees represented here today, as well as the governor's team and public safety, have been working for years on these problems, and they're persistent and they're endemic and not subject to easy solution. But I just want to give credit. Senator Sears is no longer with us. He was deeply, deeply troubled by what was going on in Bennington.
Yeah.
And so our committee spent the last, I would say, 5 years working very intensively, in many cases with the governor's team, on tweaks to the law and new penalties, new resources, new monitoring systems, et cetera. So I think that's all to the good, but it is not enough. And as you say, we need more this session. I just don't want to undercount the work that has been going on.
Oh, 100%. And our team has been, fully at the table for those efforts. And of course, we're working very hard in Bennington, Brattleboro, Springfield, St. Johnsbury, and Rutland to help those communities with their persistent crime problems. So I agree that there's been hard work and these are hard problems. And if I didn't mean to say that we've done nothing, but I do intend to represent the viewpoint of the people we talk to throughout the year, and they are feeling left behind and not considered, that the well-being of the whole is not being represented in the decisions that are being made and the actions that they're seeing taken at the local or county or state level. So I also agree. We've done great work and we need to continue to do more.
So before I go to Representative Harvey, just so today we're this morning at least, we're really focusing on the time to disposition of cases in the courts and really the swiftness and certainty of consequences and accountability. Could you address that, and then we'll turn to Representative Harvey. But if you could just comment on that issue.
So I think that there's others who can speak more knowledgeably about how we get to a place where the throughputs are faster. I mean, we have a problem with bad behavior and the consequences so far off on the horizon that it is meaningless. We could go back to the most basic of science, the hot stove rule. The hot stove rule is real quick, works real fast because you touch the hot stove once and you learn not to do it again, right? But we can also look at a body of evidence that talks about swift certain consequences consistently applied as a deterrent and modifier of behaviors that lead to crime in downtown. So that is a top priority for us, is finding a path forward towards swift, certain, and consistent and fair consequences when crime happens. And then when we get into the next step of the system in the prosecutor's office and the courts system, I'm just not qualified to talk about how to make a better mousetrap and how to make the throughputs come more quickly. So whatever that side of the equation is, we're willing to be a full partner there because I represent the viewpoint of the people who are interacting in the moment with the people who are exhibiting the behavior that causes law enforcement to be called because a harm has been done. And then what happens after that is of benefit to everyone, to the community, to those who are harmed, but also to the responders who have to go and deal with that behavior again and again if it is not curtailed immediately. So how we get there, I'm open to all sorts of considerations. I do believe that the throughputs from the time of either a citation or an arrest and lodging through to a final disposition has to be shortened. And I think we have to have strict, consistent consequences when people fail to comply with conditions of release or other, I guess I'll call them guardrails that are designed to allow them to live in the community until their case is resolved. But if they can't live within those guardrails, then we have to do something else.
Thank you. Thank you for that perspective. Appreciate that. Representative Hardy. Thank you, Chair. Commissioner, another question that, one of the common themes and concerns that I hear from constituents and from Vermonters around the state is the demographic shift and the flood of talent leaving the state of Vermont. And, I think oftentimes this is kind of conflated with the affordability crisis that we're also trying to tackle here in the state. But my question to you is anecdotally, do you hear that public safety is the chief reason that many Vermonters are leaving the place that they've called home? Because I hear that. I'm just curious if you're hearing that as well.
Yeah, to be honest with you, the things that I'm hearing about the reason why my colleagues, my friends that I did entire careers with who are now gathering pensions from the state are leaving is taxes and affordability and the cost of living. But I'm not sure that my sphere are the type of people who generally feel afraid because they spent their whole lives dealing with crime. So I'm not hearing that. I don't want to represent that I'm hearing that, but I hear a lot of agony from my colleagues who do own businesses or who like to frequent Vermont's various downtowns. I hear a lot of angst that they want what they perceive they had 5 or 10 years ago and that they want Vermont to remain vibrant. So I don't want to get ahead of myself and say anything that somebody has not said to me. I appreciate your question, but I just don't have that to share with you.
Thank you.
Any other questions? Not seeing any. Thank you very much, Commissioner. I really appreciate your time, and we will move on to Judge Zone and State Court Administrator Corsolens.
Thank you, Representative.
Thank you so much.
Thank you, Commissioner. I didn't know everybody had a paper version. I know some people came in. If you'd like a paper version.
Yeah.
Okay, great. Thanks. Thank you. Okay, sure. Everybody else has a copy they'd like? Okay, great. Oh, yeah. Do you mind if I take this to stay here? Didn't want to sit and have a judge there.
You're allowed. There we go.
Oh, good, thanks so much. Good morning, everybody. Thank you for this opportunity for us to come and speak. And given the topic of the program this morning, public safety and access to justice, we've geared our presentation to those topics and also included information regarding the backlog, because I know Representative Long, you had mentioned wanting to have an update. Last year when we came to present, that was kind of the focus of our presentation, especially in light of post-pandemic movements and data. So what I'm going to do to start off is talk about the backlog data based on our fiscal year 2024 data that's recently been posted on the website. I've kind of summarized it there, but I certainly encourage you to go to the website if you have specific questions, because it goes deeply into each county, each division for data. This is kind of an overview of the statewide picture. And then Judge Zone's, we're also going to provide an update regarding the new positions for which we were extremely grateful that were given to us from the legislature last session, judge positions and court staff positions, so we wanted to give you an update on that. And then Judge Zoni will speak with specificity about the different strategies that have been involved, particularly in the criminal division, case management arena, including remote hearings in the correctional facilities. And then also access to justice, some initiatives just to, I guess, for awareness, so that you have that perspective as well. Please feel free to interrupt us at any time with questions, and I'm going to be following, the slides that you have both on the screen and then in the paper copies as well. So I hope that will be helpful and responsive to what you'd like.
And can you send to the committee assistants the link to the report that you just mentioned that's on the website?
Oh, okay, yeah, can you do that? It's on the website.
I can do it afterwards.
Yeah, after.
Oh, okay.
Otherwise, everyone will sit here watching me do it.
Thanks.
Great. Well, that would probably be the best way. It's on, we have a statistics and reports section on the website itself, and that's where it's found, but we'll send a link that'd be quicker. So again, an update on the backlog, a statewide, very kind of broad view for fiscal year 24, July 1, 2023 through June 30th of 2024. There were 46,141 incoming cases and 48,714 outgoing cases. By outgoing, I mean cases that were disposed ultimately. And those two factors contribute to the clearance rate, which is one of the indicia of backlogs. The goal is always to have at least 100% clearance rate, that you have the same number of cases coming in per month. We usually gather the data per month and then expand it to annual, but you want to have the same number of cases coming in and the same number of cases being disposed. If you have more cases coming in than are disposed, then you're getting behind, and that's what kind of builds up the backlog. So on a statewide basis, across all counties, across all divisions, there was 105% clearance rate for fiscal year 2024, which is progress in what we, hope to achieve at least the 100%. But that's the data for the statewide across all divisions, across all units. On the next slide, just to give you,
Quick question, sorry if you already mentioned this.
Yeah.
The word cases, does that refer to just one defendant and all of their dockets, or does the word case refer to each individual docket?
The case refers to each individual docket number. So it might be one case that has multiple charges, for example, but it's a case, a docket number case. And we thought the next slide, to give you just context for these cases. Oh, I should mention as well, this includes criminal, civil, family, probate, and environmental division. We also have the statewide judicial bureau. And in the judicial bureau, there were approximately 42,000 cases, but we don't count those because those have just such a separate kind of existence. It's usually an in and out kind of short case, but just to let you know, there are that many cases in the judicial bureau as well. These cases refer to the trial court divisions.
So Senator Pahalski has a question.
Yeah, I have a follow-up question on Senator Hashim's question. So an individual might have multiple dockets or cases. Are those ever handled sort of together and not as, if an individual has 11 dockets, could that be handled as one trial or one hearing as opposed to 11 different?
Yeah, well, and Judge Zoni will address that when he talks about kind of the case management strategies.
Okay.
Because it does include, if somebody has multiple dockets, especially the people might say, the repeat offender, those are and have been by the state's attorney's office and the public defender's office kind of viewed globally, I guess, or combined, if you will. And the effort is to try to, whatever's the quickest one coming up, deal with the other ones as well.
Okay.
So that's part of the strategy that I think has been an effective strategy.
Perfect. And just a quick follow-up. So back to my example of 11 dockets, that's not necessarily a repeat offender. It could have been someone who got all 11 dockets in the same instance, yes, like multiple charges.
That could be.
Maybe not 11, maybe that's an extreme example, but.
So, for the record, Tom Zoni, Chief Superior Judge. Theoretically, that's possible, but if it's all the same incident, they would generally be charged in a single docket number.
Okay, awesome, thank you.
As separate counts.
Thanks.
And the next page, again, just to kind of, because I know you're from all over the state, to kind of give you kind of an overview about how those cases are distributed countywide. For example, as everybody would probably anticipate, the most number of cases is in Chittenden County, 9,952. Rutland has the second highest, 5,074. Washington County, 4,558. Wyndham County, 4,194. And then there are 3 counties that have 3,000 plus cases, Franklin, Windsor, Bennington. 2 counties that have, 2 counties 2,000 plus, Orleans and Caledonia. 3 counties with 1,000 plus new filings per fiscal year 2024, Lamoille, Addison, and Orange. And then 2 counties that have fewer than 1,000 new filings, Essex with 400, Grand Isle with 300 odd cases. So just to kind of let you know, that's kind of how the cases are distributed statewide. And then per division as well, of those 46,000 incoming cases, roughly 53% are criminal in the criminal division. And then civil and family are roughly equal. Civil has 18% of the total and family 20% of the total. And then probate has about 8%. Yeah.
Yeah, 53% of the cases are criminal, you said?
Yes.
What's the percentage from, say, pre-COVID? Any?
I don't know immediately offhand, but I can check and see.
Okay.
To see what the breakdown was for that. I know there was further on, there was an 8% increase in new criminal filings in fiscal year 24 versus fiscal year 23. But I don't know in terms of COVID to me came in 2020, so we have to look to see. I can look for that, but I don't know.
Yeah, just be interesting to see if there's a trend.
Yeah. I think, my sense is, in general, I think criminal has accounted for about 50% historically, but I don't know that for a fact. That's just kind of my sense, but I can confirm it with the data.
Representative Gold has a question.
Yes, thank you. And if you're getting to this, you can just say we're going to get to it, but I just wanted to tee up a couple questions. Curious if, because I appreciate the county specific, if you have clearance rate data for counties too, just to see if they're great.
Yeah, in the fiscal year 2024 statistical data, there's a breakdown per county that has not just, has all the case types within a division and clearance rates for each of those case types.
Any trends or themes that you noticed? Are there discrepancies across, or is it kind of looking pretty similar?
Oh, yeah, fiscal year 23 to fiscal year 24. Actually, a slide coming up kind of shows the difference, kind of an increase in terms of number of filings, backlog, and clearance rates, if that's helpful to you.
Okay, and that's statewide or that's by county?
This is by division, actually, statewide.
Okay.
But the fiscal year 2024 statistical data will give you every county, every division, every case type, actually.
Okay. And I guess just to be transparent of where I'm going with this, and again, maybe when we get to it, is I just know that we passed a lot of initiatives and implemented things and budget things past session, and so curious to see the impact of those. Has it actually impacted yet, or do we need to wait and see how things are to see if there's going to be an impact? So
if you're talking about particular statutes, for example, like the bail statute, Judge Zoney will be addressing that. In terms of the personnel, it's probably it'd probably be at this time next year that we will hopefully be able to say, yes, here's been this, decrease in the backlog. Because for example, the 4 new judge positions, the 4 new judge positions that were given don't correspond exactly to the 4 new judges that were just recently appointed, but those judges will be taking the bench in February, so that we wouldn't have any impact from that, at this
so for some
point in
personnel,
time.
some of the initiatives, we might not see the clearance rates have been impacted yet by things that we passed last session.
Right, although, for example, one topic we're going to make mention of is the competency evaluation statute. That definitely has had an impact, and we would attribute our inroads in reducing the backlog in the criminal division in part to that, because that was causing delays in cases being processed. People were waiting, a year for a competency evaluation, so that's had an immediate impact.
Great.
Or an impact already.
Thank you.
Sure. So that, again, is just kind of the background to the incoming numbers. And because of this hearing's focus on public safety, we've looked at, in particular, the criminal division cases, incoming and outgoing, for felonies and misdemeanors. And the next slide just shows that how many of the criminal division incoming and outgoing were felonies versus misdemeanors, and the clearance rates broken down for felonies versus misdemeanors, which were 107% for felonies and 109% for misdemeanors. And you can see also that the misdemeanors outnumber the felonies in terms of the number of filings in total. Then the next slide does give that comparison from fiscal year 23 to fiscal year 24. And in the criminal division, there has been a 12% decrease in the backlog numbers. That's based on numbers of pending cases at the end of each fiscal year, 12% fewer in the criminal division. And that was despite an 8% increase in the number. There were 8% more filings in the criminal division statewide in fiscal year 24. An increase of 3% in the clearance rate. So the 109% clearance rate in the criminal division statewide, it was 106% in fiscal year 23. So progress, improvement. Similarly, in the civil division, a decrease in the backlog. So there were fewer cases pending. There was also a decrease in the filings in civil division in fiscal year 24. That statewide clearance rate for the civil division was 108%, and that was a 2% increase, which was, I guess, 106% in fiscal year 23. I will just mention, I know there was a landlord-tenant law study committee. There was testimony on that yesterday, and they were asking about the clearance rate in landlord-tenant, which was 107%, just to make mention of that. Again, all the statistical data gives a breakdown per case type, but that was the question about what was the landlord-tenant clearance rate. Family division, we had an increase in the backlog. In other words, the clearance rate was less than 100%. It was 97% in the family division statewide across all dockets. I will mention that in the juvenile docket, the clearance rate was 109%, and that's within the family division. And we attribute the increase in the backlog, if you will, in the family division primarily to judicial availability factors. There are cases that take priority in scheduling. Criminal division is certainly one. Incarcerated defendants, the requirements that if somebody's held that there has to be a more expedited time frame for them to have their cases heard. Similarly, in the juvenile docket, there are prescribed timeframes that cases have to be heard, that they have to move. Relief from abuse cases, stalking cases, there's priority in scheduling. And family domestic in particular tends to get kind of the back burner in scheduling, because if you have so many judges and you have to handle these emergency cases and the criminal cases and the mental health cases are also on a very tight timeline, and you have judges covering for other judges, it would be the family domestic docket that suffers in terms of judge availability. We're very hopeful that now, for the first time in I don't know how long, with the 4 recent appointments, we're at a full complement of trial judges for the first time in years. So we're very hopeful. We want to kind of dedicate to the scheduling to try to bring certainly the family domestic docket up. But that's to what at least I attribute the decrease or the increase in the backlog in the family division for that reason. Probate division pretty much broke even in terms of number of cases coming in, number of cases that were disposed. They did have a 2% increase in filings overall and a 4% increase in their clearance rate. Last fiscal year, 2023, it was a 96% clearance rate, and they're now up to 100%. So they're disposing of statewide same number of cases as came in anyway during the fiscal year 24 timeframe.
Ursula, I believe this.
Okay.
Good morning.
Hi.
Not to swoop in and ask a question within 5 minutes, well, yes, to do exactly that. I just wanted to, I think, say what you're saying, but in a different way to make sure I'm understanding. So in the family division, you're attributing that decrease in clearance rate really probably pertains to family domestic cases, to not including juvenile proceedings.
Right.
Delinquency proceedings.
Right.
Okay.
The juvenile clearance rate.
Because of what you said, that as we've learned, very recently about the pretty explicit timelines within that process.
Right, within that docket. Right, for example, the dissolution, clearance rate, for example, dissolution with children, 87%, dissolution without children, 99%. And I think that That I'm kind of speculating, but I'm gonna guess if it's if it's a contested child, custody type case, that if it's several days' time and you have a family court judge that would have minimal time available, I think those take longer to schedule. The other, just kind of looking through, this is like an example of for each division, it gives each case type. Miscellaneous family, 102%, parentage, 96%. It kind of just varies depending, but the juvenile docket is 109%. And within the juvenile docket, too, you would have, it's broken down to like CHINS C, 102%, CHINS D, 114%, CHINS B, 119%. It goes to that level of detail, but the overall juvenile is 109% because of the stringent time requirements.
Great, thank you.
Okay. And, well, that kind of then ends the kind of broad overview about the backlog situation. We're hoping that helps paint a picture in terms of progress that is being made, with the exception of non-juvenile family, where we hope to use the full complement of judges to ensure that those cases are scheduled, more readily and more frequently than they have been.
Representative Dalton.
As soon as I raised my hand, I remember you said that Judge Zonay was gonna talk about this, so maybe I'll wait until Judge Zonay goes.
Okay.
Just again, the piece that I'm trying to understand is, how did what we did do last year affect clearance rates? And is it too early to tell what that impact is? Or do you already know, like, yep, we're headed on a good trajectory? Because I guess I'm thinking, as we're thinking about what the previous witness, the commissioner, said, like, there's still community concern.
Right.
Is it that we need to give some time to see how these things all come into play, or do we need to ramp things up more? And so if you could speak to what you're seeing, that would be really helpful.
I think Judge Zonay will speak to exactly that, and I did also want to make mention in terms of the statewide clearance rate across all divisions, across all counties, 105%. To me, that is just reflective of how hard judges, court staff, state's attorneys, public defenders, private bar have worked, being very mindful of the hole that we were in after the pandemic and trying to move cases. There was also data cleanup involved in that as well. Reviewing the cases, now that we have the electronic case management and electronic files, it's easier to do that, to make sure cases aren't being overlooked, that they're properly coded, et cetera. But it was, to me, progress, very good progress made, thanks to incredibly hard work by people across all, all aspects of the court system.
I think the answer to your question is a little of both. In other words, yes, it is too early to tell on some of the areas, and in some other areas there does appear to have been progress made and working forward on them based upon changes the legislature made during the last biennium. One of the changes was the legislature added 2 years ago, we had one extra judge. And that judge was assigned to the Rutland, Bennington, and Addison area. When that judge went into Rutland, and I see the state's attorney sitting to my left, so if he starts shaking his head no, somebody please let me know. What we saw was an increase in clearance rates. We saw that there was the ability to address more cases, have more jury trial days. We also saw, and this, as Terry was saying, the credit goes to the attorneys. The state's attorney would meet with the public defender. They would work on cases. But we had 2 judges every jury draw day. One could be taking changes of pleas and working on cases. The other was drawing the juries. It did work. The clearance rates shot up. So what that tells us is that if we have the judicial staff, if we have the judicial officers, that's going to allow us to address more cases. One of the things that is generally true is that where do most cases resolve? Well, most cases resolve closer to the time of trial. Whether it's at the pretrial or the jury draw, that pressure point is where a lot of cases resolve. So having that extra judge there was critical. And also, again, having a prosecutor, having a defense bar that would work together, that's also critical to resolve cases on an ongoing basis. But that pressure of the trial is something that is critical, and having the judicial officer. When you look at case flow management techniques, one of the things that comes up is credibility. If we said, well, we're gonna draw 10 days of trials, but we know we don't have 10 days available to hold trials and we only have 5, the attorneys understand that. And if you lose that credibility in the trial dates, then that's a problem. And so what we're trying to do is maximize how many trial days we can offer in each county. One of the ways that we are able to do that going forward is there were 3 new judge positions authorized last year. The way the judiciary works is that when there's judicial positions, the chief superior judge, with the approval of the Supreme Court, does what's called a rotation schedule, and we do judicial assignments to each county. Every county has different needs, as you saw in that chart, and every county does not get the same number of judicial officers. The addition of the judge 2 years ago to the rotation schedule for a float position in Rutland and Addison and Bennington was a recognition of the numbers increasing in Addison, Bennington, and Rutland, and the need for extra resources. These new judges that have been approved have afforded us the opportunity to take steps to address things all throughout the state in a manner that we believe is going to increase the clearance rate and significantly to decrease the disposition time, shorten that time between whatever type of case it is starting and that case ending. One position was a dedicated statewide juvenile judge. That was a position that that basically started with the House and Senate Judiciary Committees. And the idea was that if we had one person who was able to start looking at things in a way that had not previously been done before, we felt that that would be a benefit. And they could serve as a resource to all the counties in the state and go in and address cases. So what happened was Judge Kalfas began that position this fall. We felt it was critical to get that position up and running. And he looked at basically every case in every county. When you talk about a deep data dive, Judge Howard Kalfas did that for an extended period of time. It even started when he was still down in Bennington. But Judge Kalfas did that deep dive to see, are the juvenile cases on track for resolution? Are they on track for permanency? He had the opportunity to work with clerks, comms, judges, attorneys, to try to come up with strategies on what's the best way to schedule cases. And that includes urgent cases. When a case comes in for an emergency, if a judge is in the middle, in a county with one judge is in the middle of a trial, and they need a juvenile judge to handle an emergency, a temporary care hearing or some other type of juvenile emergency, Judge Kalfas could fill in. And that ability has helped significantly. He also can coordinate. He recently conducted a 10-day termination of parental rights case that involved numerous attorneys, numerous days of testimony, and Judge Kalfas was able to actually go into the schedule and free up and say, okay, send an email to a judge going, you have this attorney that day, I need them. And he was able to get that done. Without the opportunity of a judge who was devoted with that ability, if we were relying on the regular county judge to get that done, it would take over a year. We just know that there's not that type of time for those type of cases to get done. He also has the ability to go in and the data cleanup. He had the ability to go in and look at cases that were not meeting goals and say, we need to schedule this now and let's handle it. He also had the opportunity to see trends. What's he seeing in each of the counties so that we can get ahead of something, to be proactive and not just reactive? It has worked. It has been a significant benefit throughout the counties. The clearance rates have gone up in the areas of juvenile where he has been able to intervene and work. He's also been able to help out when we've had vacancies. And I can talk about that in a few moments. We also have, for the first time, a dedicated statewide treatment court judge. Historically, we've had a treatment court judge in the counties where there's treatment courts, and that judge was pulled from their regular docket. So in Chittenden County, it's the judge who was one of the judges in the criminal division. In Rutland County, Windham County, and Windsor, the judges in the criminal divisions would take the time and have to also serve as a treatment court docket judge. That took them away from their regular docket. You couldn't schedule things on those days. It was additional work that they couldn't focus on the other cases that were coming in. And so having a statewide treatment court judge lets the other judges in those dockets attend to the normal docket where there is the backlogs and work on strategies and scheduling and moving cases ahead. The timing is also good with the statewide treatment court judge because the national standards have just been revised. for treatment court best practice standards. And what that does is it allows us to do a system-wide quality assurance and quality improvement to make sure that all the courts are operating according to what are now the best practices that are followed. There is a heavy emphasis on assuring treatment is available in the community where the courts are. He's working on that to try to make sure that exists in each of the courts, as well as to see what potential expansions there could be. That also, when you understand what the treatment options are available in each court area, it also lets you see the gaps for what's not available. And so having a statewide judge lets him see what's going on up in one county, compare it to another and say, oh, they do this here, and brings everything together. That also allows him to work within those counties and bring in strategies from other counties that have been proven to be successful. And that continuity is something that's very helpful. One of the other things that it also does is allows him to take charge in each of the counties and come up with, we've come up with regional advisory committees, RACs, R-A-C, in each of the counties to try to work with the treatment courts. And so he's been able to coordinate that. He's been able to work on best practices in each of the jurisdictions, and it also allows him, when he's not doing that, and Judge Griffin is the current treatment court judge, he also has filled in on the criminal division, and he has helped out there, or the family division. And so he's used in other dockets when he's not in the treatment court docket. But he's straight out, if you will, on the treatment courts, working on making sure that we're doing things in a way that is benefiting each of the courts, because if we're doing it right there, we greatly increase the opportunity for success for the participants, and that leads to success for the program and success in the public for public safety. And so our view is that this is a critical position for him to be able to really make sure we get the best out of it. In doing this, when we knew that there were going to be vacancies. So we have had 2 judges, for instance, in the Chittenden Criminal Division, and 2 judges in the Chittenden Family Division. That's 1 less in each division than we ideally would like. We need more judge help there. We have historically had the ability to have judicial assistants go up into Franklin County for the family division there from Chittenden County on a float judge. We didn't have the opportunity for that. In the Northeast Kingdom, several years ago, we had 2 judges in the kingdom. One was in Caledonia, Essex, and one was up in Orleans. They did everything except the civil, which we have a civil float, and the relief from abuse and the juvenile cases, because there was 1 judge floating between the 2. And so we had essentially 4 judges handling those cases. 2 years ago, the rotation schedule was changed, and I changed it from a situation where we had that float going between the 2 counties to get 1 judge in each county. In other words, instead of having the 4 judges, we had 5. And right now, we haven't had that, because that position was carried as a vacancy waiting for these new slots to be filled. And so what's going to happen, as we sit here today, the 4 new judges are literally next door at the Supreme Court in training. Today's training is on criminal matters. The next 2 business days, Friday and Monday, they will be training on civil matters. They have a training program that goes about a month, and on February 11th, they will be operational, if you will, and in each of their courts. 2 of those judges are going to the Chittenden Family Division. 1 of those judges is going to the Chittenden Criminal Division, and 1 of those judges is going to the Caledonia and Essex Family Division. 1 of the current judges in the Chittenden Family Division is going to go from solely sitting in the Family Division there. They are now going to be working in the Chittenden Civil Division and floating up to the Franklin Family Court to assist up there on a number of days a month. That allows us to address the issues that we have had. We've heard about concerns about timing with landlord-tenant and other matters in certain counties. Adding additional civil resources in Chittenden County will enable us to shorten the disposition of those cases, Plus, it allows that float to help out in other areas. We can't sit here today and say, absolutely, it's been great, it's worked, it's reduced the backlog, because it hasn't started yet. And so, Representative Dolan, when you ask about, are we seeing changes? Well, we expect to, based upon what we saw in Rutland. With adequate staffing, with adequate security, with getting people to court, the availability of remote hearings, we do expect to see the clearance rates go above 105% statewide to start really knocking away at that backlog. And so that is the goal of how we have structured things. If, as we go forward, we see pressures in certain counties, we have the flexibility to reassign judges to address that. But what we have been focused on is filling these positions, putting them into places where we think that the new positions are going to lead to the greatest success. We are a statewide judiciary. We're not 14 separate counties all on their own. And so while today it might be Rutland that needs additional help, or Addison, tomorrow it may be Washington. It could be Windham, it could be Franklin. And so our goal is to make sure that we respond as necessary in those areas to use what the legislature has provided. And Terry, as far as provided, Terry can talk about for a few minutes the new positions, because that is critical to what we're doing.
So,
Oh, sorry.
before you get there, just a couple points that I just wanted to point out. Kind of counter to the narrative as far as in Rutland, when you added judges, that we got better clearance rate. Just, we are adding judges to Chittenden County, and I know from data that I got from you, I think it was through September, that Chittenden County had a 92% clearance rate for the past year. So we could see the results when you don't have enough judges. We're down to 2 instead of 3 that we traditionally had. So I think it's critical to kind of point that out, and hopefully we now have a 3rd judge and can start whittling away. But we've fallen further behind over the past year and a half in Chittenden County, for instance. The other thing, just and I think really would like to, if you could, perhaps at a break, and something you can send to our committee assistants, because I know that you've often provided this very quickly when I've asked, is the year-to-date clearance rate and over disposition guideline by county, and so that we have that, because I think it's important for understanding from the court, how you're using resources or shifting resources to the counties that are falling behind or are behind. I think the same question I'll have for the state's attorneys and what they may be doing differently in counties that are pushing things. Because I know it's not just the judge, and it's not just that resource. I know that things are being done. We'll hopefully hear from Ian Sullivan, state's attorney in Rutland, who's been doing some great things to move cases along as well. But if you could get us that data,
Yes.
That would be very helpful. One other thing I want to just mention is, I don't want to lose track, and you mentioned it very briefly, but the backlog is really just a part of it. It's actually not the most important part of the story. The most important part is the time to disposition, and the fact that, again, in data that was provided, and I'm not sure what that's through, what date, but there were over 6,000 cases that are not meeting the goal of the disposition guidelines, and that's where we're talking about accountability and consequences being swift and certain. Of course, yeah, the backlog is adding to that, but I think I want you to keep on focusing, if you could, your comments as well on that time to disposition.
That's 2 slides from now.
Perfect. All right, I appreciate that.
And this, I guess, to your point, Representative Lund, in terms of how we're utilizing the new positions, we also received 10 judicial assistants, 5 tech positions, and 11 security positions. And in terms of the judicial assistants, 4 of them were allocated to Chittenden. There'd been a lot of turnover recently in Chittenden, and recognition that with their higher volume, they needed more judicial assistants there. Otherwise, they were divided one to Rutland, 1 to Bennington, 1 to Franklin, 1 to Washington. Geared on, we looked at the number of permanent staff, number of new filings to make sure that the proportion was equitable across the state, because it had not been. Also, there's 2 central positions, 1 information center, where if you call a court, the information center takes the calls That frees up the local court from having to answer the calls, and statistically, I think close to 50% of the calls can be handled by the information center before they pass them on to the local if need be. Because now with our statewide electronic case management and electronic filing, they can access, when is my hearing, what's happened in that case. So the information center has been kind of very invaluable for that. The other central position is a central review. With the electronic filing, the central review team handles all incoming criminal filings, civil filings, Office of Child Support. They handle the copy requests, e-filing support. The idea being to lessen the burden on the local court staff so that they can work on the processing and not be behind for scheduling, et cetera. That's how the judicial assistant positions were used, the five tech positions. 4 of the 5 have been filled, 2 on the help desk, 2 of the public portal, a central analyst position. They're in the process of interviewing for the data administrator. That was the 5th position, and they're interviewing like 4 applicants for that, so that's almost filled. The 11 security positions, 5 have been filled with region-wide who can fill in. So that if you have a court officer who calls in sick, you can cover so that we don't have to cancel hearings. Or if there's a jury trial that requires extra court personnel, they cover so that that's not delayed. 2, we're recruiting 2, actually, 1 in Sitchin and 1 in Franklin. We have 1 who is hired but on a deployment coming back in April. And then 3 are on hold. This has to do with our Budget Adjustment Act request. The cost of living increase for the sheriff's salaries was overlooked in the last budget, so we're requesting that in the Budget Adjustment Act, but not knowing for sure if we would get it. Ideally, we will get it. If we don't, we have to cover those costs, and if we get it through the Budget Adjustment Act, then that'll free up those positions to recruit for the final 3.
Was that part of the governor's recommendation, or is it?
It was.
Separate? Okay.
Yeah, so that we saw that as hopeful. But the allocation of those positions was all based on that S-17 report, when we went around to every county and evaluated the security needs, and they're being utilized. The regional ones, it's great because instead of trying to scramble to fill it within, a county, we can allocate them to go and fill in where needed, and they're willing to do that. It's part of the job description. So that's worked out really well to not have to cancel a hearing if there's somebody that can't, for whatever reason, work that day. And now Judge Zone will talk about the strategies for moving cases.
So before we hit this slide, I would like to thank Linda Richard and Lori Canty, who are 2 individuals, along with a number of individuals in the judiciary for data. But please don't think that when I was looking at my phone that I was sitting, he's playing Wordle, isn't he? No. I actually emailed Representative Burnett. The answer to your question from our crack data staff is that pre-pandemic fiscal year 2020, 50% of all cases were criminal, as opposed to the 53% now. So there you go. So,
there may not be a way of knowing this, but I'm wondering if that is truly an indication of a trend in the change in what's happening, or a trend in the change in charging practices, or some combination of all of that, because I think sometimes we see that there's actually a trend in how things are being charged that is representing something like that. So I'm wondering if you have any sense of.
I could not opine on that at this time.
Okay, I appreciate that.
So Chair Lalonde mentioned disposition. And at its simplest point, it is when someone has a criminal charge, when they're picked up for a charge and they're charged, when does that case come to an end? As we know, during the pandemic, things went much too long. As we know, things are still taking longer than we want them to take. And the question is, how do we shorten that time? We've heard quite a bit in other meetings with different committees, these committees. You hear in the public, you see that the concern is people are violating conditions, things are happening, and we need some resolution. In 1789, George Washington wrote a letter to Edmund Randolph to be the Attorney General. And in that letter, George Washington wrote that the due administration of justice is the firmest pillar of good government. As we try to address these cases, we have to remember that as judges, that our goal is to say, what's the law? We have to apply it. What are the facts? We have to apply them and consider them. We have to look at the cases to try to move them along. And there are not always simple answers that everyone would agree on. But what we do know is that if we apply the law fairly, if we try to do it in a timely manner, we do have an increased potential for success for reducing recidivism. Because if people get the correctional assistance they need or have the behaviors addressed sooner in the system, that's going to be a benefit. And so our goal is to try to shorten those time periods. There are ways we have tried to do it by adding jury draw dates and jury trials. In some counties, we have added a number of jury draw dates and additional jury trial dates because, again, as I said earlier today, we know that the availability of jury trials and doing that is what's going to resolve cases.
Judge,
Yes.
if I can interrupt real quick. I have just a general question about, some of the factors that go into resolving a case promptly. And this ties into addressing the backlog, and I think it will also tie into some of the proposals we've received. Can you speak to whether or not there is value in a judge's ability to impose or accept in a plea agreement a suspended or deferred sentence?
Sentencing is individualized in the state of Vermont. Legislature establishes statutes that sometimes say, if you do X and you are convicted, your sentence shall be Y, and there's no opportunity. Mandatory sentences, they do exist. Outside of those circumstances, the more tools that the prosecutor, defense, and the judge has to be able to resolve cases on an individualized basis, outside of the one-size-fits-all model, is something that will definitely help reduce backlogs. If you remove the power of Mr. Sullivan, for instance, to come up with an agreement that maybe he believes is appropriate, the victim believes is appropriate, the defendant's willing to accept, and the judge is willing to accept, that case may have to go to trial, as opposed to reach a pretrial resolution. And so the more options a judge has for sentencing, the greater the potential for reducing the backlog. And many of you have heard me talk about, it's going to come up again, work crew. That was an option that judges had that we no longer have, based upon some changes that took place. And so that was very similar to the type of situation you're referencing, and that is, if you have something that's taken away that you currently have that helps you resolve cases, you might not resolve those cases. Thank you. But adding the jury draw and trial dates does work. We know that. But there's a limit. And I apologize, I keep picking on Mr. Sullivan because he's here today, but if we said to him that you're going to be in trial every day for a month, because we're really going to do it, and we said to the defense attorney in that county, you're going to be in trial every day for a month, well, what happens to their other work? What happens to all the other cases? And so there's a line of how much you can push and to maximize success and not start having diminishing returns. And we've heard about this in some of our legislator days from some of the attorneys who have come out and said, we're getting pushed really hard and we don't know that we can do anymore. And so there's that balance. Are there enough prosecutors? Are there enough defense attorneys? We're a judicial system. It's a stool. If there's not enough defense attorneys and there's enough prosecutors and judges, well, we still can't go forward because the individual is entitled to have a defense attorney. If there's not enough prosecutors, well, the case can't go forward. So it's critical to us when we look at adding jury trial dates and draw dates that we do it in a way that makes sense, not just throwing it out there and say, okay, we're going to add it. There were some counties we looked at adding additional dates in one of the secondary courthouses, but the reality then is the attorneys who will be coming up the hill, for instance in Rutland, they'd be the same attorneys who are expected to be doing trials down the hill. And so you have to be very careful. Can it be done? Yes, at different times. But it's not a one-size-fits-all model for every county that we just add a week of trials and it solves things, because it may not. Because right now, we have attorneys from Chittenden County who are helping out in Windham County, Windsor County. You have attorneys appearing remotely and helping out all over the state because of conflicts that the public defenders may have. And so there's in many ways, it's a where's Waldo? Where's that attorney today? Can we get them in this court? And so that's critical to make sure that we don't push things to a point that we're just going to start having diminished returns. So the key is to try to maximize it. And that's done through bench bar meetings, judges working with the attorneys, trying to push things at a level that's going to maximize disposition shortening. We have cases with defendants with multiple charges.
Before you do that, Representative Rachel's in this question.
Thank you, and I've been listening in the car on the way here, so thank you. I'm so excited about the new juvenile court judge dedicated position, and we'll be eager to hear more about that. So I'm wondering, you just raised a great point, because we hear from each of the groups. The state attorneys have come in and talked about where their cases are per the national standards. I think we've heard from the Defender General similar kinds of benchmarks, but those seem like they're each like in a vacuum in a way. And I'm wondering if any of the national organizations have anything about like ratio, like for every judge there, so that we're looking systemically, because we could fix one part of the system without having the best return on investment in making a difference in time to have a case get resolved, or have one system just not in a good position. So does such a more but a more inclusive type of best practice measure look at the stool?
You want to take the weighted caseload? There are studies, and there's weighted caseload studies that you can look at. There's other, from different states, national standards that come up about what works best and what we need. Where we are now, irrespective of what somebody in Chicago may think works best, our view right now, I think, has to be, we have an opportunity with more than we've ever had before. Let's see how that works. And if we find that we need more, can we get more judges to handle the work that we have?
But, so do we wait and see with the new judges what the sort of fallout is to the Defender General's office, to the state attorneys? Like, will that, it seems like waiting, we'll sort of see what the impact is on everybody, rather than saying, oh, let's fix this little other part now, unless it's like related to the data or security.
I think that it's fair to say that as we go forward, you'll hear from the Defender General, you'll hear from the Department of State's attorneys. If they think that that stool is out of balance, they'll come before you. And,
oh, I'm sure.
And if we look at it and agree with them, you'll hear us say it makes sense as a policy decision, but we want it to work well. But yes, it would be certainly a potential that, wow, there's so many judges and they're ripping through things, we need more defense attorneys and prosecutors. That could happen. And if that happens, ideally the legislature is responsive to the needs to maximize the efficiency and timeliness of the system. And with the multiple charges, this is something that I believe Commissioner Morrison and others have addressed. It's a concern that we see. And we understand that there are individuals who have repeated charges, and what's the way that you have someone not have violations of conditions of release? By have the case resolved, so that they're not on pretrial release for a year or a year and a half, so that case comes in, it gets resolved. Whatever the resolution is, if it's dismissal, if it's a plea, if it's a sentence, whatever happens, that happens in a shorter period of time.
Thank you. I wonder if you have any breakdowns. So I know there are people who have repeat offenses, but I wonder, is that the majority of the cases? Is that a minority? Do you have any breakdown of like what percentage of people have multiple repeat offenses, or maybe one repeat offense versus the percentage of people who do something,
I don't
go through the
have that
system?
with us today, but I'm sure we can get that.
Okay, awesome, thank you.
And before you move on off of this issue, I know in the past, I don't know if it was last year when we had this hearing or the year before, we talked about priority setting of the courts. And the question of whether the legislature should say, we need you to take priorities for these repeat offenders in statute. And I know at that time you pushed back and had very good rationales, I think. But I guess if you could talk about priorities, why you want to retain or keep us out of the priority setting for the courts, but also how are you going to be continuing to try to address those frequent flyers, repeat offenders who seem to be causing this concern for public safety or in the communities?
So if the legislature enacted priorities and said this is the priority, we have 14 counties. I would venture to guess that that single priority would not match equally for all 14 counties. Having the ability of the courts and the judges in the counties and the attorneys, both prosecutors and defense attorneys, to be able to try to work on cases in a way that addresses what may be the priorities in those counties that might be unique to those counties for whatever reason. That is a better approach, I suggest, than trying to say there's a one-size-fits-all model that might not work somewhere. And so as we look at trying to address priorities, some states' attorneys would go and dismiss a number of cases to say, we don't want to bog down. If we have 20 of these cases or 30 of these cases that are low level, they've been pending for 3 years, the person hasn't violated again, maybe the state's attorney there dismisses those cases. In another county, the prosecutor may say, well, I want to keep those cases, I want to go forward. But that's their priorities that they're setting. That's the type of priority maybe the legislature would look at and say, well, we want to address these types of cases. But the overall priorities are best left for the courts and the parties to try to work through with the same goal, and that is, how do we move all cases in all dockets in the most efficient way? There's an interrelationship that we have between dockets. We're talking today about the criminal docket and public safety, but housing in our civil division, that's a factor there. The juvenile cases, that is a factor there for our CHINS cases, for child protection, for permanency for children. Our dockets are interrelated because you often see people who have cases in the criminal docket that leads to something in the family juvenile docket, or it leads to a landlord-tenant matter. So we have to recognize that priorities in each of the counties are going to be changing, and we have to be able to adapt to them because the needs of the individual cases are changing at different times.
Yeah, just a follow-up question. So I know I wouldn't want the court necessarily to be setting priorities according to what is hitting the news and is out there. However, having said that, I mean, in each community there are names, and I won't mention any names, but I think in each community that's having a lot of these issues, to name a half a dozen people they keep on hearing about and are out in the community still. Is the court taking that into account, that this is an individual that seems to be causing a lot of the stress in a particular community, maybe move that case along a little more rapidly? I mean, how does
Judges,
that work?
we have judge meetings regularly, and one of the techniques that I have visited with the judges about, that I know judges are looking at, is the data. As Senator Biofsky asked, how many people have multiple charges? Well, I've had a number of charge data. We have that. Judges get that. We visited on the idea of how do we stop someone from continuing to violate conditions and bring those cases to a resolution. And so one strategy that has been discussed and that I know has been employed in a number of areas is, well, if someone has violations of conditions and they have a number of new charges coming in, we need to start the trial process. In other words, one of those cases has to go on the trial list. Because that's what's going to probably lead to a resolution and get things taken off the pretrial status of just waiting for some resolution. So you look at the list and say, okay, here's individuals, they've got 10 charges, they came in again today. You're coming on, Mr. or Ms. Defendant, next month for a pretrial, and we're going to draw one of your cases. And if we settle that case, we're going to go to the next one. And so that's a strategy that can be employed. The reality that we face, though, is that while that can oftentimes work, if you're in a county where you have, let's say, 5 jury draw days available, and you have a case where someone who has is alleged to have committed a crime and they are charged with a felony, crime of violence, and they're held without bail, they're entitled to have their trial within 60 days. So if you have that case where someone has a felony being held without bail, they have to have it within 60 days. If that's a 2-day trial, well, there's 2 of your days. What happens if you have a year or 2 before let's say a felony domestic assault, that the person is in jail, but they're not held without bail? Well, they are being held, and they have to have a speedy trial right to their trial. Then let's say you have domestic assaults that are misdemeanors with several individuals, and you have putative victims of those cases, and there's children involved. And the children are part of the juvenile case, and they're part of the civil case for landlord-tenant, and those cases have been pending for a couple of years. You have 5 trial days. Which case takes precedence? Well, we know that the 60-day case has to go under the law. After that, where do we go? Do we then say to the individuals in the misdemeanor domestics, well, you've been pending for 2 years, but we have this person who has come in under unlawful trespass 8 times in the past month. You now have to wait longer. And we recognize that that affects your housing. We recognize that affects your juvenile case, but you just have to wait. Or do we say to the person in jail, well, we understand you have a speedy trial right, but we got a lot of cases going on. And so I use that example because that is the type of decision that is being made in 14 counties every month as to how to maximize things. And that's why when I made my first comments about adding jury trial days, it is critical that we do that so that we open up time for those individuals with multiple charges. But the answer for the multiple charges has to still meet whatever the law requires. The court cannot say, you keep violating conditions, I don't like that, therefore I'm going to hold you without bail, or I'm going to impose bail. There are constitutional and statutory requirements that judges have to follow.
So before I go to Senator Bukowski, just a follow-up. So if you could comment on this, you did mention individuals being held pretrial. I want to understand how this pressure is affecting processing. That pre-pandemic, we were averaging around 450 individuals detained pretrial. Right now, we're averaging around 550. So there's been a significant, I would call it, significant increase of individuals actually being held pretrial. Does that affect, the ability to get to the individuals who are not being held?
Yes. The number from the Department of Corrections, I'll use July 1st, I believe, or July 2nd, I think it was. There were 468 pretrial detainees held by the state, by Department of Corrections, male and female. That does not include federal detainees. On Tuesday this week, there were 510, Tuesday morning. That number has gone down because of people being released, but that's where it's going. During the pandemic and after the pandemic, those numbers were not as high. We are at for people being detained, our numbers are as high as they have been in the past 5 years. And in fact, the 510 I've not seen previously, that's high. And I used the July one and the Monday as an example of when there's questions about, well, did what we do last year make any differences? On July 1st, you may recall, the law changed to say that individuals who were released on recognizance or had conditions of release, if they engage in new criminal behavior, that the court was not limited to $200 for the amount of bail. In other words, the court could go higher than $200 if it found that that was the amount necessary to mitigate the risk of flight and assure their appearance. There are individuals, I believe, and I've been advised, who are being held on bail amounts that could not have been imposed at the end of June. So that, when you ask, has there been an impact for those individuals? Yes. And so we have those cases where the courts do have more ability there to impose bail at an amount if they believe it's necessary that was not previously there. And so that looks like it is having an impact, but that impact also comes into, so individuals are held. Well, when an individual is held, they have rights to have bail review. That adds hearings. So the more individuals in jail, the more pressure there is on the court with potential filings, the more pressure there is on defense attorneys because going to visit your client in a remote location, driving from Bennington to Newport is not something that's going to happen a lot. I would suspect on a weekly basis for counsel because of the pressures. And so when you have those, you have those pressures that add to how do we fit these cases in?
Senator Bowski and then Representative Hart. And then we'll take a break after those couple questions and finish up with you after the break.
So I have a couple of questions, and I'm wondering what percentage of those 550 people that are being held pre-trial are there simply because they can't pay bail?
Department of Corrections has this, they could give you statistics on how many individuals are being held without bail and how many are being held with bail,
Okay.
pre-trial.
Perfect. I think that may be on their dashboard too.
Yeah, including the amount of bail that
Yes.
I think is part of that data.
Okay, and so my other question sort of around this and what you just testified with these increases in bail, is that indicative that bail is actually being, higher bail is being used to keep people incarcerated?
No, it's indicative of the fact that a judge previously may have felt that an individual was a risk of flight and would not appear at a hearing, and a judge may have previously felt that $200 was not going to have them appear and they were not going to appear. But a judge, based on the new law, now can look at that case and say that he or she believes, let's say, $1,000 is what it would take to make sure this person shows up for their obligation to appear in court and not flee and not appear.
Okay, but you don't think that that increase in bail is contributing to the fact that we now have one of the highest rates of people being detained pre-trial that you've seen?
I have not done a deep dive into the statistics there to see if that's it. The numbers were before July 1st, were creeping up continually. So I can't tell you, I have not done a look. You would have to look at, if you got the chart from the Department of Corrections, it'll tell you who's being held, what county, what case, what the charge is. You would be able to isolate it by charges as to which ones previously had the $200. You could then do a look into each of those cases to see if those individuals have an amount higher than $200. That you could get the data in that way, I think.
Okay, so my other question is around speedy trials. Is there a statutory definition of what it means to have a speedy trial, or is that sort of subjective?
It is case law by the Vermont Supreme Court and the United States Supreme Court have defined the parameters of speedy trial rights.
What are they?
Oh, I could get you the case. I'm not going to try to recite every factor. There was a case called Brillin that the Vermont Supreme Court decided, the U.S. Supreme Court decided, the Vermont Supreme Court decided. And so there's a number of cases the Supreme Court has decided that address what the speedy trial factors are and how they're to be considered.
Great, and what is our current average time to trial for people awaiting?
It depends on the type of case.
Okay, awesome, thanks.
Thank you, Chair. Nice to see you again, Judge Sonia.
Good to see you.
Question on bail amounts, and I think this is really interesting testimony that you just presented. In terms of the increase that we're seeing, I mean, $200 seems to be a nominal amount. Would you say that's average in terms of typical bail amounts that
Well, the
courts see?
$200 was an amount established by the legislature.
Okay.
In a statute a number of years ago, it said that if it's an expungible case, that's the court is not supposed to impose bail under certain conditions, but if the court does, $200 was the maximum. So that was the number chosen by the legislature.
In the new maximums and the discretion that judges have currently is
there's no statutory maximum that the legislature imposed. In other words, a judge has
the discretion.
They have their discretion, but the discretion is not unfettered. It's a discretion that has to be exercised with consideration to a number of factors, and those factors the Supreme Court has identified in case law.
In terms of the amounts that we are seeing, are we talking thousands, tens of thousands?
There's cases where there are cases where bail is $2,500. There's cases where bail is $25,000, $50,000. You see it all types of ranges, and the Department of Corrections does have that data.
I'm going to be digging in.
Yeah, and so that it is right in there. That's where, in fact, if you say, "Can you get me that?" I'd just send you that.
Yeah, and you think these higher amounts are being effective in terms of what they're intended to do?
Well, if someone posts bail and they show up, it's being effective. I can't say whether the higher amounts are being effective. I haven't done an analysis to determine whether or not someone who has posted a higher amount has failed to appear.
Sure. Thank you.
Thank you.
Okay, let's just take a brief break. I'm going to say 5 minutes so that it will not turn into 15. 10. 5 minutes. All right, welcome back to the joint hearing of the House and Senate Judiciary Committees. And we're continuing testimony with Judge Zone and also Terry Corsone. So I think you're on the third item on that
So one of the things we've also done is, as I mentioned earlier, we try to increase the number of judges we have in a courthouse at the time of jury draw days. So that way, if you have 2 judges there, if a judge can be taking changes of pleas, if the parties know that there's the availability of that instead of having to wait to do it and keeping jurors waiting during the day, it increases the potential for resolutions. And finally, we've talked about it, Terry and I have mentioned a number of times today, data. Judges do get data. If a judge wants a specific report that can be generated, they request it, we can get it for them. We look at data constantly to try to identify areas that we can improve upon or to see what's working right and to try to make sure that's implemented throughout the state. One of the things that we hear quite a bit about recently is about remote hearings. And I wanted to touch base about that for a bit. Remote hearings assist us in the courts. They're not a substitute for people coming to court. We're not going to have criminal jury trials remotely. We're not going to have certain other types of hearings remotely. But there is a place for remote hearings, and they are critical to our ability to move forward. There's disagreements at times, and people have concerns about challenges that we have with regard to the remote hearings. A few years ago, one of the challenges that was identified was it was a little 12-inch box, and you couldn't see, you couldn't hear, things weren't going well. There have been tech improvements since then. The judiciary has now dedicated internet circuits for more reliability, 47-inch screens versus the prior 12-inch ones. There's modular equipment, which means we don't have just a one piece, so that if something goes wrong in the different modules, we can replace it out, and that will help keep things moving. And there's metal cases that have been added that DOC has the ability to access. There's second remote hearing devices that have been deployed in all but 2 of the correctional facilities. DOC can use those for individuals when they're, for a number of reasons, one of which I know is sometimes there's mental health screenings is an area that they can be utilized to assist with. There are changes that are going to be going forward with additional improvements to the technology in the jails, as well as a request I know has been made to try to have minis expanded. A mini is something, it's a device that would let individuals within the jail access remote hearings from within the jail if the main system is potentially being used by another court. One of the challenges I think they have, that the judiciary has had with that, is wiring, to make sure that the wiring works. And I know that our tech people are working with the buildings and grounds to try to figure out the best way that I guess matches with security and such to be able to improve the wiring there. But that's the direction we're going in. But again, is a remote hearing the end-all, and that's the way we're going to do all hearings in all cases? No. People should come to court. There's a need for it in many cases for different reasons, but there's also a need for the remote ability. And the remote ability is something, as I mentioned earlier, you have attorneys who are helping out in conflicts throughout the state. They're not going to be able to be in Chittenden County and in Washington County and Bennington County all the same day if they had to be there in person, but they might be able to do it remotely. There's times where individuals are housed far from the court where their case may be. There might be challenges to get them transported to the hearing, and you might be able to do that remotely. Currently, the initial regional arraignments are done remotely in most of the courts, and that is something that we're aware of challenges that have been expressed there, and we're looking at trying to make sure that the hearings that we are doing remotely are being done in a way that facilitates the interest of justice, and that we address any challenges as they come up. But the reality we face is that being remote in many of these circumstances is necessary. We don't have the availability to have sheriffs transport every day to every court at 1 o'clock for people who may have been held the night before. There's not the availability of transports for that. And we also have regularly scheduled hearings. And so the sheriffs, if they're scheduled for certain hearings one day, and then you have 5 or 6 people get arrested, can they get them there in time? Our understanding is that the Department of State's attorneys and sheriffs, that the sheriffs in every county does not have the bandwidth to be able to do that. So that's something which has presented a challenge for getting some people to court. We're trying to work with the Department of State's attorneys, the Department of Corrections, and the Public Defense with the Defender General's Office to say, okay, what are we doing well? Let's keep doing it. What are we not doing well? Let's change it and do it well. And so those are discussions we're moving forward on. One area that I have recently testified on earlier this week, and I said it, and I joked with Isaac Dana from the Department of Corrections that he could stand up and object when I made the comment, but we're aware of the challenges that the Department of Corrections is facing when they do remote hearings. They have staffing challenges. While years ago, case managers at the department, case workers, would help set up hearings and provide paperwork back and forth to the courts and defense attorneys, getting it signed to move things along. That's not happening now. The department does not have the bandwidth for that, and it's not workable under their standard operating procedures. The department has worked with us to try to facilitate remote hearings at a level that it believes it can handle. But the reality is we need more. The ability to have a remote hearing that is scheduled, that is conducted at the time it's supposed to be conducted, and that is predictable, that's helpful to everyone. The attorneys need the ability to make sure if their clients need to have conversations with them confidentially that there's a location, that's arranged. The attorneys at times need to have something signed. If you have an attorney, and I've used the example of Bennington to the northeast up in Newport, but if you have an attorney who has a potential plea agreement to get signed, and that plea agreement can be a remote hearing to resolve the case and move the case forward, it's difficult for that attorney possibly to drive up. It's not as difficult to email the paperwork to the jail, have a staff member print it off, have it signed, have it scanned and sent back, and have the case go forward without the individual having to leave the jail and bring in the sheriffs for a transport. And so there's something in it for everyone. If the Department of Corrections would be able to have one additional person in each jail who was dedicated to basically being a caseworker type situation where they facilitate remote hearings and they help out in other ways. And then when they're not doing that, they have the ability to help out the department. So I just point that out because that's something that I think some individuals who have been involved in the judicial system for a long time, we do remember when the case managers did those things, and it did help. And now it would be helpful again, but that's up to the Department of Corrections.
So on that issue, probably not next week, but the following week, there'll probably be a joint hearing between House Corrections and House Judiciary on remote hearings and transports. And we'll be digging in a little bit deeper with the Department of Corrections as well, and state's attorneys and defenders and you folks. So
I would like to be very clear that there have been times that the Department of Corrections has said, we are not going to facilitate X. And based on discussions that we have had, they have subsequently said, we will facilitate X. The commissioner and the staff has tried to work with us. And I understand that the areas where they might not be able to be on board with suggestions or requests that we have, their position is that it's staffing and challenges that they're facing there. And I certainly understand that. And I don't view it that they're not trying to work with us. They have stepped up to the plate, and certain times on emergency circumstances, they've been great, and they help us out to facilitate the interest of justice. But we just think that there could be some areas that we all improve on there.
All right, so about 5 more minutes, and we do need to move on to the next couple of witnesses. So
The timing is good. We're on our last slide, and it really just has to do with access to justice, which, because of the public safety access to justice title of the presentation, we wanted to just kind of briefly make mention of, for awareness of efforts to, encourage or facilitate access to justice. One is an access resource center that we have that started out to be basically designed to accommodate a walk-in clinic at the Costello Courthouse, but it was set to launch right before COVID when all walk-in activity at the courthouse ended. So with the shift to remote hearing capability that happened during the pandemic, we shifted the focus of the Access Resource Center to become more of a statewide resource that people can take advantage of. Self-represented litigants at any courthouse in the state, they want to connect by phone, by email, by video, whatever. They can, to people who are their focus is to help self-represented litigants navigate the system, whether it's with forms, whether it's with questions whatsoever. So the Access Resource Center has developed into something that's become a very valuable statewide resource that if somebody's at the courthouse in Memorial and somebody really needs a lot of help, that you've got 4 people in line and you can't really dedicate the half hour that they need, they can then be transferred to the Access Resource Center, people who can help them one-on-one. So just so people are kind of aware of that aspect, or that resource. Then also Vermont Judiciary Commission on Mental Health in the courts, recognizing the great number of people that interact with the court that have mental health issues. This commission is a tri-branch effort, and I know Representative Lalonde, you serve on it, as well as Senator Lyons and Commissioner Demmel, Commissioner Morrison. The Defender General's Office has Marshall Pohl as his representative, and Tim Lueders from the State's Attorney's Office. So it's a tri-branch effort with legislators, judiciary, and executive branch agency personnel who are all involved, who are stakeholders in this issue in general. And that's something that the competency evaluation bill evolved from Senator Lyons being on this commission and hearing all of the issues with competency evaluations, proposed the bill that was enacted. So that's kind of just an example of something that this tri-branch effort has accomplished to date. What they're focusing on now and in the coming year are sequential intercept model workshops that have been held in the Northeast and Northwest. They're scheduled in 2025 for the Southeast, Southwest, and Chittenden, where in that region, all of the different stakeholders, whether it's judiciary, executive branch, or legislative branch, meet to assess what's available and try to collaborate, not duplicate, and come up with an action plan for the best way to kind of address the needs of people, and ideally be able to divert, if it's not somebody, they're better treated not in a court setting, to take advantage of the resources there. So just to make mention for awareness of that aspect. And then lastly, we have a Vermont Judiciary Committee on Artificial Intelligence in the Courts that just was created this past year to try to identify how artificial intelligence can help with processing, can help and actually with access to justice for self-represented litigants. In other states, they have chatbots that are connected with the website to help self-represented litigants navigate the forms, navigate commonly asked questions, et cetera. So we want to look at how we can take advantage of that tool, being mindful of risks, but there's different committees that have to do with actually evidence rules and ethics rules and things like that, but there's also a court operations committee that looks at how can we use it to help self-represented litigants, to help court users better navigate. So I just wanted for kind of awareness, make mention of those bodies as well.
So we'll probably want to go deeper on those last two issues at future hearings. Senator Bahalski, if it's quick.
I hope it's quick, but I have two hopefully quick questions. So with the current state of things, if nothing were to change, about how long would you expect it to take to clear the backlog?
I don't know what's coming in the future, so I cannot opine to that. I know that there are other people in the room that have opinions on that.
Okay.
I'm looking at Matt Valerio. I say that because he was talking about it as we were leaving, but I don't know what's coming in. I know that that will definitely affect our ability.
Okay. So also I fully understand that the 4 new judges are just getting started, even though they were authorized, I think, in July. What do you anticipate being the increase in clearance capacity with bringing these 4 new judges in?
I can't anticipate it as we're going to see it in this docket or that docket for sure.
Okay.
But what we're looking for is something well over 105%.
Yes.
Our goal is as high as we can get. If you look at the clearance rates on a monthly basis, sometimes it's 150%, sometimes it's 160. So would I like to see 150% in every court, in every docket? Absolutely. That's not going to happen. So we would like to see it definitely increase from where it is now at a number of points higher.
Okay.
And we'd importantly like to see more cases meeting the goals for disposition guidelines. But before we go, we're going to go to state's attorneys, but I just want to flag a few issues that we didn't get a chance to discuss, but we will hopefully be bringing various folks back in. Work crew, which you mentioned, we're definitely going to have further discussions and probably a bill related to that. Also, whether there are cases in certain areas like driving with license suspended that are over a certain age, should those be dismissed? Rather not have the legislature do that, but we're going to consider something like that. And definitely need to look a little bit further at competency. Individuals who are found to be incompetent to stand trial and are cycling through the system. And my understanding, either Senate or House committee will be looking at those things. Just want to flag those things that those are issues that we hope to get to, but for now, we'll jump to the state's attorneys.
Thank you very much.
Thank you.
Thank you.
Try to be as quick as possible. And I'm going to share my screen. Tim Leaders-Dumont, Executive Director, Department of State's Attorneys and Sheriffs. And with me is the state's attorney who has been mentioned on a number of occasions this morning, Ian Sullivan from Rutland County. All right. Let's see if it starts to share. All right. Don't worry. You'll have these slides, but we're not going through them.
You're not going to read them?
I often leave it. I leave a digital trail wherever I go of information that I hope you find useful. And that's what happens when you invite attorneys to a hearing. So yes, with me is State's Attorney from Rutland County, and you're looking at the data analytics team for the Department of State's Attorneys and Sheriffs. And it just an acknowledgement, we don't have data professionals in our department, but we have people that are experienced with the cases that we are working with, and then we extract data from our partners at the judiciary. And I want to give a specific public shout out to the judiciary's data team, which sends us the data, which then we analyze for caseload analysis, et cetera. This morning, you'll have these definitions. Just as a reminder, Vermont has a different definition of felony and misdemeanor than most other states. In Vermont, a felony, a crime punishable by 2 or more years, and misdemeanor by less than 2 years. Many other states have a 1-year marker for the felony. As we talked about, the docket is often referred to as a case. Could include multiple counts, which are sometimes also called charges. But noted an 11-count information is what we would refer in Vermont to how we charge things. Most things in Vermont are charged by information, which is basically an affidavit accompanying an information that we sign instead of a grand jury. We can do grand juries, but they're exceedingly rare. There was one that occurred recently in Lamoille County. We talked about clearance rates briefly, but it's the number you file in, the number you get out. So if you file 100, you get rid of 100 by disposition. That's a 100% clearance rate. You'll see on the left here the dispositional guidelines, which help set the barometer for what is backlog on the left there. And here's my favorite new AO, administrative order from the Supreme Court that they recently published at the end of December. And I highlighted some pieces here for you to look at later, but basically there's the Administrative Order 5 and there's Administrative Directive 24. Those two administrative documents help the courts set priorities for what gets priority in terms of case time in the courtrooms. I highlighted my favorite parts of this, but basically AO5 is entirely discretionary. The trial court has the discretion to determine in each case. And there's an acknowledgement at the end of this past year that the timeframes are not essentially realistic in the world that we're living in today. In fact, the time periods are often confusing in that they conflict with dispositional guidelines. All of this to say, we're all trying our best. You stole my stool line, but the 3 legs of the stool are all trying their best. And we really appreciated this acknowledgement of the reality that despite our best efforts, we are not meeting the backlog goals that I think we strive for. And that the last one I might to mention, the timeframes are discretionary, however, they do not bind the trial courts or entitle defendants to dismissal for non-compliance with those trial dispositional things. Basically, we can't dismiss cases just because the court system cannot handle what we're putting in there as a result. We shouldn't have that be a rule because it would cause a lot of societal harm, in our opinion. Now I'll hand it off to State's Attorney Sullivan.
And I'll just make an observation that there was a report of a joint subcommittee of the Criminal Rules Advisory Committee and the Criminal Justice Oversight Committee on speedy trial issues to the Vermont Supreme Court. Post Odyssey, the court's, I'm still saying new, but it's actually a couple years old at this point, new case management system. The richness of data that can be extracted from the judiciary is so much greater than what we experienced in the past. But because the system is relatively new, we kind of have 2 sets of data that we are looking at for speedy trial disposition. One that is newer and very rich, and one that is older and that isn't quite as granular in terms of the type of data. So while that speedy trial subcommittee's work, I think, was very helpful for those people working in the system to kind of grapple with how long it is taking certain case types to get to disposition. There's probably more that can be done once the new data set expands over time, especially in the area of super complex cases, your homicides, your sexual assaults, your kidnappings that involve really a wide set of evidence to grapple with in order to bring the case either to trial or to negotiated disposition. We are going to send out this slide deck. There's a lot of numbers on it. What we are looking at here is a statewide data poll back in December of 2023. And this really covers our world as the Department of State's attorneys in terms of what we're dealing with. Felonies, misdemeanors, fish and wildlife, civil suspension, then all the juvenile dockets, delinquencies, youthful offenders, and then children in need of services, A through B. The closer to A you are, the more severe the situation the child was in. Then we have a few other areas that we work on that are not necessarily huge numbers, but civil miscellaneous, which tend to be extradition matters to other jurisdictions. Those ebb and flow. Kind of just depends on when people are in Vermont and when they have an interaction with law enforcement. JBA are Judicial Bureau Appeals. So while there are a lot of Judicial Bureau cases, there aren't a ton of appeals from the decisions of the Judicial Bureau. State's attorneys are empowered to work on ordinance prosecutions. You can see that back in December of 2023, that was extraordinarily rare, only 8 across the entire state. And then PCRs are post-conviction relief matters. The statutory jurisdiction for those are people who are in custody under sentence. The decisional law kind of expands that beyond just those words, but they are potentially very intensive pieces of litigation. Anytime we're looking at data sets, the window of time we're looking at and the scope of what we're pulling in really matters. What we are looking at here is a point in time, December 10th, 2023, and with all case statuses. So that will include active and inactive cases. And at the time, 26,119 pending cases. We did, if we can jump to the next slide, a data poll on December 10th of 2024 to try to give you guys a look, essentially 1 year later. And the bottom line number on the screen, 23,134 pending cases, does show that there has been movement and downward movement in the overall pending cases across the state in all of the case types that we as state's attorneys and our deputies work on. I'll just note that in the December 2023 data set, we did not include extreme risk protection order cases. We did in December of 2024. There were only 3 in December of 2024. So those cases are urgent. They're very time intensive because there is an extreme threat of suicidal or homicidal violence. So it's important that we move quickly and move intensely on those cases, but they are not a huge number of cases. So there's just that one category difference between the two data sets. And the next slide.
Before you go,
oh, sure, yes.
Can you say why, like I'm curious
Sure.
why you picked December 10th?
I've got to pick a number. Yeah.
But
I'd
in
be happy to talk
general,
about that. I mean, just briefly, it is before the holiday season.
right, well, it's in the middle. so-
Yeah, it's before, yeah, exactly. It's before the end of the year.
Right.
And we often, it's right as we're sort of getting to our ends of year stuff. In January, all of this happens. There's a ton of reports. And so we thought it's a good end of year opportunity to sort of do a check-in. And we've only done it for a year now.
Okay.
And the reason we didn't do it, I think, at January 1, et cetera, is because there's just so much activity. It gives us very little time to analyze. Last year, we had a meeting with yourself and Representative Lalonde about our caseloads. It was very close to December 10th, which is why we pulled it on December 10th.
It was my son's due date.
Oh, okay.
But I'm wondering.
Well, that's why then.
Right, but I'm wondering if we looked at June 10th, would those look very different than December?
So-
Because sometimes,
Yes.
like I know the homeless count is.
Sure.
one-
So I can kind of answer that question, and that answer would really be based on filing data. We tend to see a cyclical filing data trend where the summer, warmer months tend to have a higher number of incoming cases than the winter.
So
possibly
opposite of other types of services, which is interesting, right? So, okay.
Yeah. And admittedly, summer is the time when attorneys, judges take vacations, so fewer trials happen. So the disposition can tend to be slower.
Thank you.
Good question, though. A pretty random number, other than it was close to the end of the year.
Yeah, and as Tim said, this is the analytics team. I have a very full-time job the rest of the time. Ideally, I would do this monthly. For Rutland County, I bugged the judiciary's data team for data sets for us because I incorporate data pretty heavily into our case management and think it's really helpful. But to do a statewide analysis, it probably is 3 or 4 hours of my time, and that
Thank you.
can be a challenge to carve out.
Thank you for that. And Tom, in terms of Oliver,
While we're on the subject, and I should know the answer, but I don't, so I figured this is a good time to ask. When law enforcement sends you a case, at what point does it start to actually have a record? Suppose you decide not to prosecute. Is there any data stored on that? Even if it's complete, it has all the elements fulfilled, the whole thing.
We can go over the timeline of a case.
Yeah,
But I mean,
so yes, the answer
you
is yes,
decide, I'm
but
not
not
gonna-
in this data set. This data set is coming from the judiciary, so if a prosecutor elects not to file, there will never be, unless I'm really missing something, there will never be a judicial record of that in the criminal docket. If, there's a wrongful prosecution.
I'm just looking
civil
at
suit.
your records.
So our case management system is no longer supported by the the company that provides it. We are in the process of getting a new case management system that hopefully will give us a much better way of internally managing data and producing reports on things like that. But our current case management system, if entered into that system, there would be a record of a declined prosecution. I'm well aware that there are times that a charging decision can happen between a police officer and a prosecutor talking about a case at 3 a.m. Yeah, and in that case, if the prosecutor elects not to file a charge, the officer might not send the case for a formal declination letter, and then that stat would not appear.
I'm just wondering if we're missing like a bulk of something that's like, well, we don't have time to even do these, or.
Sure, I mean, I tend to think of this as an inverse pyramid. At the top, kind of citizen interactions where they've called the police, things where the police officers believe there's probable cause, refer for prosecution, actually filed cases, and actually filed cases is what judiciary data would capture.
Okay.
Senator Balsky.
Thank you. The 3 a.m. conversation between a prosecutor and a police officer, are you referring to sort of the pre-charge diversion type cases?
Oh, sure. Yeah, it could be that. It could also be an instance where one that is immediately coming to mind from my personal experience is an instance where there was an act of violence in self-defense that I believed was justifiable, and while there might be probable cause to file the charge, the defense was so strong that I did not believe it would be just to proceed. So that person not sending to a pre-charge diversion program, I believe no crime had been committed.
Okay. Thanks.
Sure. So this, I think, is where things can actually get interesting, and I did an Excel abstract art to cover a comparison. So red, making progress towards decreasing caseloads, green, showing growth in caseloads, and the important caveat I'll give is these are 2 points in time from December of 2023 to December of 2024. So fortunately, there's a lot of red. That's a good thing. That's a great thing. That means we're making progress in a lot of categories. But I'll observe some counties that had already made a ton of progress on their backlog. They were at such a good starting point that there was less opportunity to make progress. Kind of specifically Washington and Windsor County, they had done a ton of work on their backlog before our December 2023 data drop. And the very bottom line is a percentage decrease. Now there are some areas where the percentage decrease is pretty pronounced. In the juvenile delinquency category, 21 and change percent decrease, and in the CHINS B, a 40% and change. I know, I apologize, it's small. We will definitely be sending this out.
You can zoom in as much as you like.
Yes, yes. But those are smaller relative caseload numbers. So for example, we do see kind of the fallacy of small numbers showing up in that. For example, in Wyndham, they saw a 112 case decrease in their juvenile delinquencies, but in 2023, they only had 141 juvenile delinquencies. So they can't possibly repeat 112 cases, right? They would somehow be at negative numbers. That's not possible. The areas where we have the largest number of cases, so the most stable data sets, are going to be the felonies and misdemeanors. And there we saw just shy of a 6% decrease in felony numbers and a roughly 8.75% decrease in the overall number of misdemeanors from those 2 points in time. So single-digit progress in reducing the backlog, in reducing the overall caseload. That's 1 year. And while that is progress, I suspect every community that every one of us represents expects that the system will deliver timely justice, and single-digit changes are probably not enough to get to timely justice for all of our communities.
So just a question on that. So my understanding that Chittenden County, it looks much more positive there, and Franklin County as well, because both of those counties, at least the court-reported data that I've seen, had below 100% clearance rates. So how does that reconcile?
Year, fiscal
Yes.
year, we, again, the crack data team here, but we used a calendar year essentially, and the judiciary's data that you just saw was fiscal year.
And the other thing,
wasn't that data, it was different data that I've seen that actually has like a 12-month rolling average, and it's that rolling average that I've seen is below 100% net.
we will have a slide later on that summarizes each month's, in another piece of abstract art, each month's clearance rate data. And one of the, I think, interesting things about clearance rate data is that, you know, if your monthly average is, say, you file 100 cases, and in July, you resolve 200 dockets, you would expect that is a really good month on resolutions. But if in July you just have, you know, whatever, a crime spree that causes 205 filings, you've got a negative clearance rate there. So clearance rate and gross numbers for clearances can sometimes have a little bit of distortion relative to each other as we think about the data. And that's one of the reasons I would encourage people to think that there is no single yardstick to measure progress, but that we really have to look at a number of different measurement tools to get a complete and holistic sense of what's going on in our criminal justice system.
So Representative Harvey and then Representative Goodman.
Thank you, Chair. Just to be totally clear, in terms of the distinction between calendar year versus the fiscal year data, we still feel that this is very representative of the current landscape and climate. Like if we rerun your numbers using fiscal year data, we're not expecting a dramatic shift in
We are working
numbers.
off of the judiciary's data, so I would expect it to be in lockstep.
Great, I just want to make sure.
Yeah. Good. Yeah, different window, but same underlying data set.
Ian, you kind of answered my question, but I'm just curious. So as we're trying to assess the health of the judiciary, what other factors should we be looking at beyond clearance rate and backlog? And in fact, I'm thinking to myself, I don't even really know, when does a case become a backlog case? Like how long does it need to pend? All these things. Are there other factors or data points that we should be considering when we're trying to assess the health?
Sure, so I think age of cases matters a lot, the volume of filing, and this one is a little less tangible. Are people getting trials when the case is ready for trial? No matter who somebody is in the system, a community member, a criminal defendant, a victim of crime, they really deserve their day in court so that, right, in our democracy, justice happens in front of a jury, right? The government either has to put up or shut up, and if it is taking such a long time that nobody feels like they are getting their day in court on a timely basis, the efficacy of having that day in court, to my mind, drops off pretty significantly.
So the age issue is time to disposition essentially?
So I'll add a caveat. So yes, but, right, lawyers love saying but. Yes, but I think the active time to disposition is probably the more helpful way to think about that. The reason I say that is there are a number of reasons that a case might go inactive. A person could absent themselves from the court process for a period of time, right? They could go on warrant status. And saying, hey, this person was absconded for a year, 2 years, they are perhaps differently situated than a person who has been waiting for their day in court, showing up, asking for their trial month after month.
So are we able to distinguish the pending from the active cases for time of disposition?
So I know that in the Speedy Trial Joint Committee, we did some work on that. And that is one of the reasons I say that the data set is definitely still growing. On some of our more serious cases that we would expect take a long time, the window of time we had to look at was perhaps too small to really tell on those cases, on your murders, your sexual assaults, your kidnappings. Kind of the meaningful active day to disposition on some of the cases that we would expect a speedier disposition, a retail theft of a six-pack. Those cases that should be getting done in 6 months or so, we can see that. And there's a much higher number of those cases in the system to look at. So you're not looking at a relatively small number of cases. And I am thinking back several months now, I cannot remember if that data made it into the final report. I cannot remember off the top of my head if that made it into the final report.
Thank you very much, Chair. Tim, this is actually going back to a comment that you made earlier. I just want, before we go too far into the testimony, I just want to make sure that I fully understand. You made a comment that, you know, we shouldn't be dismissing cases because of potential burden to the system. I just want to make crystal clear for this group and for anyone that's listening to the testimony, we aren't currently seeing that, are we? Cases being dismissed because of a potential burden to the judicial system.
So the comment was from the Administrative Order 5, which noted a case that had made the comment that non-compliance with the dispositional guidelines, basically saying you should get rid of your misdemeanor within 130 days. Non-compliance with that should not result in an automatic dismissal of the case.
Right, but we aren't seeing that.
We are occasionally seeing that.
We are occasionally, okay. Yeah. Interesting.
Yeah, there are dismissals that are taking place due to the staleness of the case.
And that might really happen in two ways. Either one is an act of prosecutorial discretion, the prosecutor elects to dismiss a charge, or two, there is a motion filed, a Rule 48 motion that has a complex set of factors based on State v. Save that ultimately allows a judicial officer to make a case-specific, fact-specific determination about that case.
Thank you.
Yeah. And we can touch more on that probably on at a later hearing date about what's happening with some of that. The next one is, we can blast through this one pretty quickly because you heard from Judge Zone on these numbers too.
Yeah, so at the very beginning of the slide deck, you will see the dispositional guidelines for under disposition, near over disposition guidelines, and NA cases. As I mentioned earlier, the window of time and the scope matters a lot when we're talking about data. So this is derived from the judiciary's monthly backlog snapshots that come out roughly on the first of every month, but are targeted at the first of every month. And so this is a slightly narrower scope than the slides we shared earlier. And so this covers the calendar year of 2024. And with this narrowed scope, starting the year at 14,984 and ending the year at 14,015 cases. You can see...
This is criminal only.
Criminal only, yes, thank you. You can see relative stability across the year in the number of cases in the over disposition category. A dip at one point in late spring, but then by the end of the year, back up in the neighborhood of 6,300 cases in the over disposition guidelines category. But an overall, using this data set, reduction of roughly 6.75%.
So just a time check, you've about 5 more minutes, we need to turn Matt Blair.
Well, boy, I'll start talking faster.
Well, maybe if we can get through as many of these as possible, and if it's okay with you, Mr. Chair, we will happily come back and answer any questions.
Yeah, we'll individually find spaces in our committees to, because we are gonna need to have more information to understand how to support whatever.
And this will be sent to Nate at the end.
So this is a graphical representation of the total pending cases from the monthly backlog snapshot. It's just a picture rather than numbers. The next 2 slides.
We'll go straight to this here.
Oh, good, yes. So this slide captures our pending homicide dockets as of December 10th, 2024. In querying any data set, how you do it matters. So this data set includes any literal charge of either manslaughter or murder. That means it will sweep in attempts and conspiracies along with the completed murder. So 96 is the number. Here you can see the year of filing. So not necessarily when the murder or manslaughter was alleged to have been committed, but the year in which it was filed. Probably all of us are well aware that sometimes it takes a while to solve these cases. This does not capture investigations but yet unsolved murders either.
Could we get that slide in distinguishing attempts?
We will try, but again, you're looking at the data team. We'll try.
Yes, I believe that would be possible.
It's dependent. We literally are searching an Excel sheet, and so we'll have to sort it. I think we could probably do that. But
yeah, I believe that's possible.
Yeah. Okay, so this one we're not going to touch on too much, other than Senator Wachowski I popped this in when you were talking earlier. The repeat offender conversation. So just at the bottom there, this is an interesting slide in that I've removed the names of the defendants on the left side of the screen. Over on the right, you'll see the total number of pendings for each individual. So each of the rows is an individual. So we can see the person with the highest number of pendings was 74, but there's a number in the 20s. And as a sort of takeaway number, there was 150 people with 10 or more dockets representing 2,100 open dockets. So, relatively small group of people that represent thousands of dockets. And then this will also be in your slides, but on the next screen, here we go, repeat offender. Also, as of this date and point, this is an interesting slide we've repeated for the last few months. Number of people on the left, number of open dockets relating to that number of people, representing total number of dockets. So that look at the very bottom of the screen, 667 people with 5 or more open dockets representing 5,307 dockets. Meaning, again, it's just there is hundreds of people representing thousands of dockets or cases as sort of a takeaway that we talked about a bit last year when we were coming up with the 5 or more for the pretrial supervision program that's in a pilot up in Orleans right now. I'll also just mention, just because our labor relations manager is likely watching this hearing, we have 300 to 400 cases per attorney in our department, about 600 cases per victim advocate. The victim advocates often work with more victims associated with each case, meaning one case could have 5, 10 victims. And there's a number of reports that this is a snapshot, so it doesn't include the flow through. So prosecutors are clearly handling more than 400 cases per year, which is not in the best practices, to say the very least, according to a number of reports, best practices of societies across the country. And that's just something we've talked about the last couple of years. So our workloads are very high, and we'll talk about resources on a different day.
So I think we do have to move on.
Okay.
And I apologize that things always take longer than we expect. But we will look at this information. We're going to have you in because we are going to want to understand how to support requests for resources in the next budget. And so probably in the next couple of weeks, we'll have you in at least, Tim, and hopefully Ian can join by Zoom. We'll try to find a time that he can join. So I apologize that we...
Thank you. Thank you. Thank you for your time.
Thank you. So, It's all very important information, and we definitely want to get it all, but we'll make sure that we have you back.
We see the floor to Mr. Valera.
There's certain benefits to going last. One of them is not having enough, but one of the downsides is not having enough time. Yeah, well, it's one of the things I've come to
Well,
know.
you have until noon, so I think I give you 2 minutes less than what I understood that I would need, so pretty close.
Well, yeah, assuming I get everything up.
Well, yeah, there's the technology, the extra 10 minutes for technology fixes.
And somebody sent me a link, I hope.
Maybe if you send Matt Valerio a link.
Okay, good. He is right now.
I'd love to know how many self-reports that.
Did you get the link? Sorry, I sent it.
Yeah, I got the link. I am now tempted to see.
You're all set.
Okay. I did just attempt to share the screen.
So is Matt the co-host?
Yep.
Yeah, can you go over to Zoom? Yeah, I was there.
Is this how remote hearings work, by the way?
Yes. That's your whole screen, not just the slideshow, so you're all set. Perfect.
Okay. By the way, this is exactly how remote hearings tend to work. I condensed, State's Attorney did a lot of slides. Court had a lot of slides. I don't have a lot of slides. But what I tried to do is condense it into something that makes the big points. All right? We do everything on a fiscal year basis, so it's always July 1st to the June 30th. We are a couple of years ahead of the state's attorneys regarding our case management system, so I have data from our system that is that I think is reliable based on our fiscal year calculations. And by the way, I am Matt Larry, I'm the Defender General, for anybody who doesn't know. I know there are a couple of new people, but not too many. In any event, the criminal backlog for the first six, we track it in a couple of different ways, but I took a snapshot from June of '24 until December. And while overall you're getting a little blockage at the bottom there, at the beginning of the, if you look in June, we had a 14,164. This is from court data, by the way. Backlog, and then at the end, come December, we're at 13,826. So you see a bit of decline, but you're talking about 300 cases.
Are those active cases, pending cases?
All active.
Okay.
And those are ones that are all past disposition guidelines. What you see is a incremental progress being made on the backlog during that period of time. However, if you look at the counties, I highlighted in yellow some of the counties where, if you kind of split them, you've got Addison actually saw an increase in the backlog. Franklin saw an increase in the backlog. Grand Isle, not that big a deal. It's 3 cases. Orange County, an increase. But these ones, Washington, Wyndham, Windsor, all increases in the backlog. So while half the state is reducing the backlog at some rate, the other half of the state is not. Some is reducing it by small amounts when you compare like June to December, and others kind of go up and down. If you kind of track it, this is what we saw during this period of time, where we saw a decrease in the backlog under 13.8, then it started to creep up during the summer, which, by the way, and I don't know if any of you remember this from the last time I was here doing this, this is what you see every year. You start to hit the summer months, and that backlog and the caseload starts to increase. You hit the cold weather, it starts to decrease a little bit. But if you look at it as a whole, and I had our spreadsheet basically give us an average, we're effectively flat. That little red line that goes across, yeah, we're making a little teeny bit of progress, but we aren't making very much progress.
Before you go, I just want to confirm, so your definition of what is in the backlog are cases that haven't met the disposition timelines?
I'm using the court's measure, yes.
Okay, so that's the next, all right.
We're talking about the exact same data.
Okay, thanks.
Because I pulled up, all of this data is from data that I got from the courts that they send me monthly. So I keep track of it on a county by county basis, and this is showing it aggregated for the entire state. This is
has a question.
Yeah.
Yeah, so I'm wondering if the summer increase in clearance versus the winter decrease, is that due to fewer cases
It's
coming in?
not increase in clearance, it's increase in backlog.
Increase in backlog, okay.
When it goes down, then you're.
Okay. So what my question is do you see more cases coming in the summer and a sort of flat rate of clearance and less coming in the winter? Or is it actually that our attorneys are less productive in the summer, or is it?
No, it's increasing cases.
Okay, so there's more cases coming in the summer, which is?
More cases are joining the backlog.
Okay.
As you go through those months. This is not unusual, by the way. The court backlog is not something new. The size of the backlog is what's new. We've always had a backlog. One of the running things that we've always discussed within the public defense system is, for example, Rutland is one that we always discussed. Rutland traditionally always had 1,000 case backlog. Always. We were always really happy when it dipped under 1,000. That was Yahoo, but typically it was always around 1,000. Then they'd throw some more resources that go in for a period of time. You'd beat it back to 900, and then the resources would go away and go back to 1,000. This, which you can't see on the screen, the last time I did this, I did the same presentation in December to kind of show up my troops where they were in their particular counties. But this breaks it down by felonies, and this is actually added cases for the last fiscal year. All right, that would be fiscal year 24. Backlog in and of itself is not the total measure of what the issue is in the system, because backlog is only those that are over disposition. What is following the backlog is this. We saw an increase in felony cases in fiscal year 24. Not huge, 1.2 in charges increase and 1.4 in cases. When we talk about cases versus charges, cases are people. Charges are counts, charges, right? So we saw an increase of 1.4% in felonies. In misdemeanors, we saw an increase in 3.4% in cases, 4.6% in charges. Here's the one, I made it all red so that even if you can't see anything else, we saw almost a 60% increase in other cases, which are primarily probation violations, and a 47% increase in probation violations, the charges related to that. So total, we saw over a 7% increase in added caseload going forward. These are broken down. If you see on each side, there's another. The screen I was using before was literally the size of that wall, so you could see it. But in any event, this is all broken down by counties. Like you'd have the counties over on this side, and I highlighted the ones that seem to be more, bigger increases. And so you're talking about like Chittenden County and again, the Washington, Windsor, Wyndham area. Those are going down the bottom. You see small increases. But the bottom line is we're following up a backlog that is reducing at a single digit rate, 2-3%, with 7% overall increases in clients and charges. Right. I even have data up through the first quarter of fiscal year 25 has been scrubbed. So, and these are broken down by the counties as well. Bennington County has seen a massive increase in both cases and charges. We also, if you see this whole bottom part with Orleans, Rutland, Washington, Wyndham, Windsor, all have seen increases. The good thing is that Chittenden, as a big county, has seen a 7.8% decrease. But overall, we are again seeing for the first quarter, and I guess you can see it, we see almost a 6% increase in cases, which are people, with a 4.4% increase in charges in the first quarter when you compare quarter to quarter, fiscal year 24 and fiscal year 25, right? So backlog is one thing, added caseload is a whole other thing. The bottom line is these cases haven't made the backlog yet, but they're coming. And whatever's in front of them that is sort of clogging the pipe has to get resolved, or these guys are going to end up in exactly the same situation, which is a backlog. I'm glad that the slide that State's Attorney showed corroborated what I saw when it comes to family cases. There's some good news and one piece of really unfortunate news. The good news is in fiscal year 24, we saw a reduction in Chins A, Chins B, Chins C, Chins D, delinquencies. All of those went down by healthy amounts. However, we saw a 40% increase in termination of parental rights cases during that same period of time.
40%?
Yes. And when I see that, over the last 24 years, what I feel is that somebody's made a policy decision about bringing those cases. It's one thing if you've got 3%, 5%, small amounts that'll fluctuate. When you see 40%, somebody's making a decision. And I don't know what that decision is. I was stunned by the number. It may also be, and this is fiscal year 24 in total over fiscal year 23. All right, we're in 25 now. So that kind of increase says somebody's making a decision.
So where would such a decision be? In the state's attorney?
No.
No, I'm sorry, I'm gonna have to address this, because you notice it wasn't in our data, because we don't do the TPR.
Right.
Okay, so not.
Just wanna put that out.
No, this is not their, no, the chin stuff was the same thing, we're talking about the same thing. TPRs, however, that's Department of Children and Families, makes that decision, the Attorney General's office. There might be some change in leadership at DCF. Sometimes I see there's a new training that happens, and all of a sudden now training has filtered out to the district offices, and they're making decisions about what cases need to go to TPR as opposed to trying to find permanency by extending the chins cases and doing administrative reviews that put more work into trying to reunify families. That's just a big number. I don't know the answer, and I don't know that anybody would actually tell me the answer. But it's concerning because we do those. And when you're doing a TPR and you're doing it right, this is the quote unquote murder case of the juvenile docket. You get serious experienced lawyers spending an awful lot of time, taking up a lot of court time. And when it gets to those cases have priority over the criminal docket. They have priority over the civil docket. So when you have that going on, the court is not able to get to the backlog that it's seeing in the criminal cases. So I find this slide interesting, but I don't have exactly the answer of why. I only have, from my experience over a long time, when I see this, it suggests something. The added family cases, this is just a graphic way of in total seeing what went on quarter to quarter, first quarter, half year, 3/4, and full year, comparing fiscal year 23 to fiscal year 24. Some people like to look at graphs more than they like to look at the numbers. But you can see that overall, that docket is, when you go over a full year, because of the volume of the various CHINS cases, has gone down, but for termination of parental rights. This is it's a graphic way of looking at fiscal year 24 compared to 25. In fiscal year 24, we saw this big increase in felonies, almost 8%. Comparing quarter to quarter, that first quarter of 24 to the first quarter of 25, misdemeanors are actually down from fiscal year 24 to 25. Felonies were up, and other cases went through the roof. Probation violations and the like. And overall, it aggregates to the first quarter, seeing a 5.9% increase in the first quarter overall caseload. So again, this is that back pressure that you're seeing on the backlog that hasn't hit the backlog yet because they're new cases, but they're coming. So when we come back next year and we say, where are we? And you wonder, well, why are we not making more progress on the backlog than you would hope. It's not just what the backlog is, because the backlog's not static. The backlog's constantly being fed by whatever's going on before it ever becomes a backlog, all right? This is every county for fiscal year '24. We already talked about the increases that we saw, and with the huge increases in the other cases, which are primarily probation violations. I put this in here because I know legislators like to check out their own county and see how they're doing. And you can see where some have had decreases in caseload. Grand Isle should be very happy. Lamoille County has seen a decrease in caseload, but a lot of other counties, Bennington is up. When Chittenden County is up, that's a problem because it's 39% of the total state caseload. And then you've got those, what I consider like this, Chittenden's a whole world in and of itself, okay? Take Chittenden out of everything, but look at Orleans, look at Rutland, look at Washington, Wyndham, Windsor. Those will tell you a story about, Bennington is another one, kind of those, all of the counties are not exactly the same, but sort of mid-range sort of caseloads. All of those are telling you the story of where the caseload is, going up. And you're seeing double-digit plus in many of those. Windsor's doing okay with their essentially flat with a 1.4% decrease in their caseload. But if you want to check out your particular county, I'll have this sent over and you can take a look at it. This is just another way of looking at the data that I've been talking about, and I highlighted the double-digit increase counties that without the breakdown of felonies, misdemeanors. If you just want to look at it in gross terms. Yes, that's all, folks. In any event, there's another piece of this that I think I want to talk about, which is very concerning. It's been growing over a period of the last 10 years. It's become more acute in the last 5 years. We have a fair amount of resources deployed, but we have a smaller number of people doing more work. We have, and whether it's in the staff system or the contract system, we actually have less contractors and less staff doing more work because there aren't enough lawyers to actually take the work. In the last year, have had openings that have they're sitting there, we're advertising, we don't even get applicants. And I'm not talking about those that are contractors who they don't get benefits, they don't get, none of their overhead is covered. These are the conflict contractors, so to speak, or the serious felony units or the like. I'm talking about fully benefited staff positions in Rutland, in Chittenden, in Franklin County, in the Prisoner's Rights Office. I've had positions open that have sat open anywhere from a year to 18 months where they don't even apply. And the lawyers, there are not, I don't know, it's two things. Number one, the demographic of lawyers is shrinking significantly. The bar is aging. When I came in, I'm gonna be 62 years old this year. I came in during the kind of boom of lawyers coming into the state of Vermont that came in the late 80s through the 90s. That number is falling like a stone. And the vast majority of lawyers are now my age. They're not 20s, 30s, 40s. And we aren't replacing them. So we get almost no lawyers from in the entire state, we get almost no lawyers from Vermont Law School. They're not even worth talking about. You're talking literally single-digit number of lawyers applying for jobs in Vermont from Vermont Law School, even seeking to be licensed in Vermont from Vermont Law School. Where people are coming in is from out of state. When they come in from out of state, it's one of two ways. Number one, usually is they've practiced for 5 years and they're coming to waive in having practiced for a period of time in another jurisdiction. Those are not the people who generally want to do public defense work because they have some establishment in their career. Tends to be that public defenders are a young person's game. You know, you get the 30-year-olds. You know, you don't get the 40-plus-year-olds applying to be public defenders. And the other thing we have is some who are coming in within their first couple of years. This is a smaller, much smaller amount. We have the uniform bar exam, right? That some number of states have adopted. Vermont did some number of years ago. I didn't know at the time. We had a conference on this. Chief Justice came and talked. We were all there. I think Terry was there. I didn't know what I didn't know how it was going to cut. Were we going to get people from out of state, or was it going to make people who are in state, like from VLS, would they take the UBE, Uniform Bar Exam, and then they go somewhere else because it transfers the other way just as easy as it transfers this way. We haven't seen any benefit from that to speak of. The people we're getting are the people who are more established in their career coming into the state. I've been on the Vermont Bar Association Board of Bar Managers for over 30 years. I was president a long, long time ago, 20-something years ago. But the difference is marked in the way that demographic of the bar is presenting itself to us. Why is all this important? Because we can't fill positions to do the work that needs to be done to address the backlog in particular counties. What I've been doing a lot of is moving deck chairs. I'm transferring people from Rutland to go to Chittenden when they have an opening. I'm transferring people, from other, from central office to Bennington or whatever the case may be, to try to fill openings to kind of just keep your kind of fingers in the holes as it's leaking on you. But we aren't getting new applicants. We've had a little reprieve in the last couple of months because the New Hampshire public defense system right now is in a tailspin. And and many are abandoning New Hampshire. And I've been able to hire 3 public defenders who have been public defenders for a while out of New Hampshire, but I have 7 openings. So I got 3, now I'm down to 4 openings. Anybody here from Franklin County? I have two openings up there that I haven't been able to fill in months and months and months and months. Hasn't been a year yet. On the one hand, we're very proud that Mary Kate Lanther became a federal judge. Trying to fill a Rutland opening, oh my God. It's like, I'm just thankful that the people in Lamoille County are hanging in there because I've never been able to actually fill a position there. I just have to transfer somebody and give them more money because I can't get anybody ever applying for it. We're also in a position now where our Orleans County primary public defense contractor gave notice to me last June that they were not going to renew that contract. Some people have expressed interest, but as of right now, nobody has stepped up. So I may be faced within the next month saying I have to establish a staff office up there instead of a contract office, which it has always been for, literally 30 plus, however long the public defense system has been around, since 1972. That's how long there's been a contract office in Orleans County, and that may have to be a staff office, but I don't know how I'm going to hire anybody up there. It is very difficult to hire people, and you see this in many states. New Hampshire has the same problem. Maine has a different thing going on because they have a pseudo public defense system, but rural public defense systems, legal aid offices have extraordinary difficulty hiring anybody, and this all impacts backlog. So all of these things where I'm saying, I've had 2 openings in Rutland County, I've had 2 openings in Franklin County. Those places are gonna be your next hot spots in your backlog because there are not lawyers there to do the work. I have moved contractors in to try to absorb some of that caseload temporarily, but that's a Band-Aid. Ultimately, you gotta be able to fill those positions. So when we're talking about access to justice, like this meeting, we're talking about dealing with backlogs, dealing with caseload increases. You can't forget, and I know the state's attorney's, Tim left, but I know that you maybe you can speak to him.
Yeah.
Do you have any trouble hiring?
Oh, absolutely.
It's impossible, and it's both sides. I think public defense might be a little less attractive to some folks, but it is hard, not hard, almost impossible in some areas to do it. And it's almost by, kind of the grace of God, me being in the position as long as I have and knowing where I can go to try to siphon off lawyers from, I hired a bunch of lawyers from Colorado at one point.
In Rutland.
I got 2 in Rutland.
Yeah.
I had another one up in Chittenden County, and then there was another one. And
She went back.
yeah, 2 of them went back. Why? Because Vermont's too cold, and they came from Colorado. I'm like, come on.
It is colder.
Apparently it is, and one of the things they said, your winter lasts till like April. And apparently in Colorado, that's not the case. I didn't realize there was such a big difference in climate. But when it snows there, apparently it goes away relatively quickly, except for in the high mountains. And spring comes earlier. Who knew? But I thought it was going to be perfect. They have public defenders coming from a cold place, going to a cold place, should be good. But that is the thing you kind of run into. And it all impacts, in the rural counties particularly, the access to justice and our ability to dig out of these backlogs. And it's a constant challenge. And it's much more acute now than it ever has been. Every now and then we add a new contractor. But it usually means I've already lost 2, and I'm trying to fill these holes. I almost, when Judge McManus became a judge, I was like, oh no. Because, yeah, it's great for her, but like, how am I gonna hire in Bennington? When you create these holes, there's not a readily available line of people who wanna take the job. So it's not just numbers, it's not just added caseload, it's capacity to handle that caseload. And we don't have it, and I think given the demographics of the bar, it's gonna get worse before it gets better. So
with that good news.
Yeah. I don't know that anybody, if anybody who is other of our partners in the justice system disagree with a word I said, feel free to raise your hand.
No, absolutely. And we do have a bill to see, some sort of stipend situation. Ian's working on it with me, and I've already touched base with you about that, but that's not the answer probably either, but maybe well.
Well, honestly, it's not the money. It really isn't the money, because I haven't hired anybody at entry level in 5 years, maybe longer. I started higher on the pay scale. It's not the money. So anyway.
Well, I appreciate it, and we will have you back when we actually see the governor's budget and as far as what we're going to want to do as far as advocating for appropriate resources for the criminal justice. So we're adjourned until the House Judiciary Committee is adjourned until 1.